amendments. Thirdly, so I think, Chair, just maybe a bit of so in terms of this process, maybe Younger can come in. Younger, do you just want to go through the process? Because, Chair, we have always talked about the fact that these text bills to be draft bills. And certainly, I think we've tried to say it may both houses have joined draft, so that it becomes easier then to deal with money arrangements if Parliament wants to effect changes. Because by the time I guess it comes now, it's not impossible, but it does become more difficult. So I don't know if there's a need to go through all these slides of all the many processes. Younger, do you want to just go through the first few slides?
No, before you do, for the sake of Parliament's integrity and our integrity as the NCOP, I need to say a few things before we move on, lest there's misunderstanding. Firstly, your explanation of the process, how difficult it is for the NA to effect any amendment should we so decide, is correct what you are saying. In other words, I don't want to go into all of that because what it does, I mean, I'm not saying you did anything wrong. I let it pass, but I wanted to rule you out. Because what it does is it makes members feel slightly intimidated that, look, if we agree with stakeholders, whether it's business or NGOs or whoever, whether we agree with them or not, what is the point? Because the process is so complicated, okay? That, you know, it has never been done before. It doesn't mean that we can't do it now. I'm sure you agree, as does your team. Secondly, it is unprecedented in 1996 that we have this number of amendments, right? In fact, when we planned the program, it was on the bill to say he wants to lobby us. In fact, he asked for a private meeting with me. I will not mention the person concerned because it's not fair on him. A Zoom meeting, an Exemption Commission, and that's correct. You know, excellent. Let me also say, Momo, as if I haven't said this to you offline, Younger is an excellent representative of National Treasury and the rest of the team. And even quite frankly, if you want to talk of an ambassador, so to speak, of the department, or an ambassador for Momo and Momo's thinking on tax issues, she's great at that. In other words, she has largely a similar approach as you do. So you're a piece in the pot. Please be assured that despite your considerably greater experience, she manages the committee exceptionally well. And you know that, right? So you see, basically, Momo, let's not intimidate members. Let them come to their own opinion and then look at what's practically possible. Secondly, there's another point. We do have the power. And therefore, the fact that we haven't exercised it is presumably because we never had to. And it's possible that we have to now, given the unprecedented nature of submissions. So insofar as the particular person approached me, if you like, I will confer with him offline and in fairness to you and your team, explain to you, and I can give you the letter. I said, no, it's not appropriate that you meet with me before the hearing. You are going to be at the hearing. If you do meet me, please understand, it will not be fair to other stakeholders. Secondly, I don't make the decisions. Yes, a chair is influential, especially we've been around for so long in New 64, you know, but ultimately it's the ANC study group that takes the policy decisions. Sometimes they agree with me, sometimes I agree with them, sometimes we don't. And also, there's no point. What would be the value of you lobbying me? Nothing will come out of it. I can just hear you. And I'll have to report to the committee that you lobbied me. So the person never replied that I know. Maybe the thousands of emails I got a reply. So please, if they were lobbying members, because you were here when I mentioned this on Tuesday, Mr. Momanyat is not referring to me. He's talking to lobbying, I don't know who, maybe members of the executive and department officials. But there's been no lobbying, nor has there ever been in a situation like this. As a chair, you meet endless numbers of people, but never in a situation like this. So no, there's been no lobbying for me. Then on the process, why I let it pass more, because that's for Frank Jenkins and me to deal with, is it's alerting new members that even if we decide there are practical problems. But the problem is not with you, Treasury, except that you came a week late, which we understand with your budget, with your MTBPS, and we lost a week. The problem is the way the NCOP and NA manage our respective programs. This very day, in the House, it was raised by Dikeledi Mashlangu. It was raised in our committee meeting yesterday. Dennis Ryder is going on ad nauseum about it, right? We can't disagree with somebody simply because of another party. The problems are bigger. Dikeledi and myself have said we're going to engage NA chairpersons, and we're also going to engage with the chief whip and the NCOP house chair. The days are over, where the NCOP comes in at the end. I'm telling you, with Charles de Beer, he used to raise it with me, and we used to do our programs where we'd say, okay, he's desperate, let's bring our program a week earlier. Now, even then, Momo, I never appreciated how much of pressure they have. But then they didn't have the situation of 13 submissions, whatever their source. Forum shopping, as Momo, you know, that's their right. At the end of the day, Parliament must do what is right in respect of stakeholders. Otherwise, our democracy is dead. And Momo, you are one of the people, no matter what they say about you, the stakeholders, I know, do consult, you do engage, though you're quite tough in giving any concessions to us, as if we need your approval, but you know how we have to fight, you in particular, and Treasury in general, with policy changes on tax bills and other issues. What we have done, colleagues, for those of you who don't know, new colleagues, and also civil society, where we extract from stakeholders what we agree with, we get National Treasury to make the policy change because it's easier because of the torturous Money Bills Act process, especially towards the end of the year. The other point I need to make again and again has been made by stakeholders, and striking me more now, Momo, that the rates and monetary bill we can pass easier, get it out of the way earlier. These two bills, you need to also think about your complex process. It needs to be brought forward by a week or two so that the NA finishes earlier and the NCOP has a bit more time. But these issues, Momo, we dealt with in the Money Bills Act. Charles de Beer and his team raised, and the comrades from the NCOP raised those issues. Frank tried to deal with some of those issues. But you know what? Invariably, when it comes to this time, it means extending the week of Parliament into December. There's no time for constituency work, and the rules and regulations have to be managed in a different way. So what we're dealing with, Momo, is not you and us. We're dealing with a broader issue. You are right about everything you say, but we should not, colleagues, be intimidated. But the reason this discussion is taking place with Momo, it's because it's a new dimension to our role, colleagues and comrades. And not one of us, not least Dikeledi and I, were in the NCOP ever before, which is a bigger problem, Momo, that the majority party in particular and other parties need to think about, that this constant circulation of MPs, even those who come back get allocated to committees which they did not previously serve in the NA. So many of those people have been made chairs of other committees. That's an internal ANC problem. The ANC that you once were so active in. The problem is not yours, Momo, or Treasury's, or ours. It's a broader issue, and we can address it, colleagues. And I don't think we should party political positions on this. I'm being very sincere. The DA is right, the EFF is right, Fani Duto, Freedom Front is right. What has happened over the last 3 weeks on appropriations and finance committees is not acceptable, really. So, colleagues from the other parties, we agree with you. We can't disagree with you because it's not a party political position. It's about doing what we are constitutionally mandated to do. We've done enough, Momo. Thanks for your input. But colleagues, don't be intimidated by the tough process that Frank explained to me and Momo's explained now. Let's look at the thing on its specific merits. That's the reason I found Frank, Momo. I can't speak about it online. Frank will speak for himself when the issue arises. I spoke to him for a few minutes until 1725 about what happens if we do accept any policy and these constraints. What are, and I offered him an option and he said, no, that's a possibility. He would have said the same thing. So there are options, colleagues. taking into account what Momo said, what I said, I'm speaking for Frank, which I shouldn't do. He'll speak for himself at an appropriate stage, either today or our next meeting. Can we now move on, Momo?
Yes.
On the process issues, yes, it will be helpful to tell them.
No, Chair, and I think exactly, I don't think there's any issue here, and I think you have to apply your mind to each and every submission that's there. I have been told, Chair, incidentally, that to receive this for the sugary tax, beverage levy, and the car tax, I'm told, but let Younger and others come in. Younger, do you want to kick off with the slides?
Yes, Chair.
So, Chair, we've got a response document, obviously, to made.
I think we've got the slides. I just want to ask the Chair that we're going to do oral presentation on the things that were orally presented in Parliament. Our slides are in two parts. There are oral presentations on the issues that were orally presented in Parliament on the 24th in NCOP. And we've got the second parts of the slides, which are all the written submissions, those submissions that were not orally presented in Parliament. And I think, Chair, I think this year there were challenges regarding the timing because we are normally at NCOP earlier. But because this year there were 5 tax bills that Parliament considered this year, that is SECOF and Standing Committee on Finance, because beginning of the year we had COVID-19 tax bills. Those were the 2 tax bills. And now we've got our 3 tax bills that were part of the legislative cycle. I think also because we normally go to NCOP round about September and all that. But this year it has been difficult because of the COVID-19 tax bills, because the timetable became a little bit shorter, or there was a lot of issues regarding the timetable, because this year one can say that Parliament has to pass altogether 5 tax bills, of which the COVID-19 tax bills were passed on the 5th of November, Chair, and we are very grateful for that. Coming to the consultation process, I think, as we have said earlier, the bills were published for public comment on 31 July 2020. And it is important to note that these bills give effect to the tax proposals mentioned in the budget, not the COVID-19 tax proposals. The COVID-19 tax proposals were not mentioned in the budget because they come after the budget of the 26th of February. So they were mentioned in the but before, sorry, in the adjust, we had public workshops. There were oral presentation to the Standing Committee on Finance. And then on 13 October 2020, we responded to the Standing Committee on Finance on the 2020 draft tax bills. It is important to say that most of the written comments that are raised here in this committee, we have made changes already, and then we've been tabled by the minister. So it may be the case that the stakeholders that submitted some of the written comments now have not seen that some of the comments have been taken into account in the final bill, which is already on our website, which was published on our website during MTBPS on 28 October. So we can go through on the side with the stakeholders with those changes that they have not seen. On the 24th of November, that is on Tuesday, there were oral presentations as well as written presentations. The committee dealt with, for the purposes of time, we can do the oral presentations, but we've got the written presentations on the slides. Hence, we've got about 70-something slides on this document. The next slide, Chris, I think you have to...
Younger, can I just come in about process issues, right? So firstly, what matters is not, what matters is not, firstly, 70 slides will be very tough, because remember, they're going to reply And then, you know, I think instead of you replying, let us engage, and then you can reply to them and us at the same time. Secondly, you see, it's the themes that you need to pick up, the major themes, right? And it's not been necessary to go through 70 slides. I mean, we found a lot of overlap. I've started reading them. I've read about half of them. There's overlaps and similar things and so on. So, you know, just manage the time. You know, it's 6:05 now. The meeting is meant to finish at 8:30, right? It's a 3-hour meeting because of the use of data and so on. We have 3-hour cycles. So we got up till 8:30. I think, you know, you should adroitly use, let's more, please, because that'll take us to 6:45. It gives us enough time for a discussion after having heard civil society stakeholders. Now, in Kulileko, can you just help so that I can manage the time? Otherwise, we were rushing at the end, and certain people will feel they were not given enough time and so on. So how many stakeholders are here? I'm looking at the participants. I can't recognize some of the people. They might be not connected to stakeholders. Will you just look up how many of the stakeholders are here and tell me how many so that I can manage the time better? But is 40 minutes okay for you, Younger?
Yes, I think 40 minutes will be fine.
Good, okay. Let's deal
Because
with that.
we're going to raise only the issues that were raised orally here in Parliament, Chair.
No, that's a problem we have, you see. The way we function as a committee, I think people should not be penalized. With Frank in the last. And to oral as to written data. Frank, are you here? Frank, is he here?
Yes, I saw him. He was here, Chair.
Yeah, I thought he told me he's going to be here, but I don't see him on the list. Oh, Frank, here you are. Frank,
yes, Chair, I'm here. I'm here.
Just give me a quick answer. Am I right to say that the same weight has to be attached to a written?
Yes, 100%, Chair. No, 100%. It's a submission.
Good. Let's move on.
Okay. Yeah.
Frank, if necessary, you can come in later on the other issues.
Okay. I think, Chris, for the purpose of time, because from slide 5 to 10, you can start, Chris, on slide 10. That is on increase on excise duty on tobacco. Yes.
Thank you, Chair. Thank you, honourable members. We had a few comments on tobacco from both sides. The one was that the excise duties on tobacco are too low. They should be increased substantially to mobilize additional revenue and reduce consumption. We shouldn't worry about greater illicit trade with tobacco from high excise duties, as there are a lot of other non-price factors that will have an impact. So we do recognize that there is illicit trade, and it is something that we factor into our thinking about the excise duties increase. We do have a guideline that we follow, that is the 40% of the most popular product and 40% of the price. So we do need to have a multi-pronged approach to this. Enforcement is critical, control and monitoring of supply chains, dealing with organized crime, sharing of information, etc., to try and deal with this illicit tobacco. I know this committee and the Senate have had quite a few meetings and sessions on this issue, and will continue to be one. The minister really, is up to his discretion in the budget on what he can do, and excise duties on tobacco are one of the instruments that we can use to raise additional revenue. Already this year, we need to raise additional 5 billion next year to help with fiscal consolidation. The next one was, I think it was similar. It was about, there could have been a much higher increase. It was only at inflation. We have been increasing by much higher than inflation. The World Health Organization recommends it should be at about 75% of the retail selling price. At the moment, we're only at 40. And we do look at these things in terms of what our guidelines should be. On heated tobacco products, there was a oral presentation on that, on the rate that we are implementing here. The proposal and the presentation was said that it was an error on our part, that we didn't include the net basis. This was not an error on our part. We did not do that erroneously. We did do it based on the full kilogram, so that it's based on the weight of the stick. The proposal was that this would provide an unfair treatment and it would not be comparable across other heated tobacco products. And we've already said in the response document that we recognize that it is not perfect. It's a very broad treatment of these products, and they are very different. They're all new products, so that we're seeing these types of products for the first time. So it is a very broad category. We said we would refine it, but it wasn't an error. We said that it should be about 75% of the overall price, 75% of the excise incidence of a normal pack of cigarettes. A normal pack of cigarettes is around 17 Rand for excise duties. If you apply this methodology where you take the kilogram of the stick, it comes to around 13 Rand for a pack of 20. So they look almost, and they are very similar to normal cigarettes in that they come in packs of 20s. And if you apply this formula, it gets very close to the 75% of what the other price is. But we have said we will look and try and refine at budget later. And the next one is on export taxes. I won't go through due to the time issues, I won't go through the background rationale, but essentially government is trying to provide for an export tax on scrap, which will allow for good quality, affordable scrap to be used locally, which can then potentially have downstream impacts as the inputs for manufacturers will reduce the quality of the percentages that we've applied for the different scraps. We dealt with quite a few comments previously, but again, they came up to say that, they should not be classified as free for free trade agreement for SADC countries. Should only it should only be free if the final destination is in those countries. So the proposal is to get rid of that free for one, or to have a rebate, a conditional rebate on the value of the export duty if you can prove what your final destination is. We need to be very careful here. We do have trade agreements that bind South Africa in these ways. If you impose if you impose an export duty on a good to a country where you do have a trade agreement where it says there shouldn't be export duties, we are worried about the impacts of those trade agreements and undermining those agreements. We think the risk of circumvention is relatively minimal. There is quite a small amount insignificant amount of scrap exports that have gone to EU and SADC. So we can monitor this, we can check how much is going, and then we can see. We didn't agree putting in a conditional now. It'd be very difficult to put in. We're only just starting this tax for the very first time, and this would be quite a significant administrative complication for it in terms of how you approve it, as well as how SARS officials would approve it. We need to see how this goes initially and track those exports to see whether there is potential abuse. That covers the first part of that as well, the upfront amount and the rebate. The other point was we should rather have a quota system. So instead of saying, yes, there have been very few exports to SADC in the previous years, we should say that you can only be allowed to export up to that amount in the future years. So you can't have a huge increase in the value of your exports to SADC. Again, as part of the trade agreements, we need to be very careful that we don't violate those in terms of restricting trade to these countries where we have these trade agreements. So we will monitor this, we will check, and if there are very large increases, we can then do something about that, and maybe use those other articles in the provision to allow us to try and protect our tax base. The other one was on moving to a percentage rate rather than the unit rate. The comments here are saying that an ad valorem rate could lead to under invoicing, for example, and it should rather just go back to the unit rates in the original proposal. I think there was also some notes from a document I saw from Parliament that was asking the same question. So I'll go back into the rationale for why we moved to an ad valorem rate. The unit rate.
Sorry, it's a very useful interjection there by you, because I forgot to mention that as late as it's come, they're also under their own pressures. We're meeting all day these days. Esther and her team, Poppy and so on, they did that document. So I was going to, well, Njadu said he will take responsibility, as can members from all the parties here, to ask those questions not answered. So National Treasury, please, when you reply, if you've had a chance to look at the questions done by the research team, it'll be good if you replied like Chris is doing right now. Thanks, Chris. That's helpful. It'll save us time. Thank you.
Thanks, Chair. So yeah, part of it was on what is the rationale for moving to an ad valorem unit. So we did extensive consultations with the industry. We went with both sides. So obviously the industry that are supplying scrap are very against this, but they also don't want the ban on scrap to continue. Whereas those who use the scrap, would obviously want the proposal. And, export taxes really are, those instruments where you take from one industry to give to another, and I hope you get these wider benefits. And there are varying grades of scrap within each of the, if I go back to these line items. So as you can see in, for example, stainless steel or copper waste and scrap, you get varying grades of the type of scrap. You get grades that have much higher value and you have grades at much lower value. If you have a unit cost, then it would, in some instances, completely get rid of the market for some types of scrap that aren't even used locally. Because if the unit value of that price is just, it's prohibitive for you to export that value of that scrap if it's low value, you're not going to export it. But nobody is using it locally in the industry anyway. So basically you're shutting down an entire market for no reason. We wanted to avoid that. Similarly, for very high value scrap, we wanted to be able to get an additional amount of the export of the tax actually on that value for the very, very high value, because the percentage will be a higher portion rather than a fixed value. Secondly, scrap metal prices are, vary quite quickly based on international market demand for these types of goods. There were a lot of calls in the previous round to say we must institute a mechanism where we are changing the unit value of the export tax every quarter or even more, based on what is happening with the international prices. If you move to an ad valorem rate, you completely remove this requirement of government to act every few months to try and keep this appropriate and keep it going. The ad valorem value will automatically adjust based on rand value exchanges, based on the demand for the actual different types of scrap. It's a much more flexible and versatile way of implementing it. The next comments were saying that the values are just not high enough. They're saying that the value, for example, for aluminium is too low and it should be increased, say, to 20%. At the moment, we've taken the recommendations from ITAC and the DTIC in their investigation into export taxes, and we've taken those values. We will see how the tax pans out and then move to different values, but we are going to review them and see how they work in practice. I think there was the one big point that there were 2 points from the note that I saw, but also in the oral presentations, was about under invoicing, and SARS aren't going to be able to administer this. The revenue servers deal with invoicing on a daily basis, because in imports they have ad valorems, they deal with this all the time. So they have assured us that they are able to deal with this, and they are able to look at measures to make sure that there is not under invoicing, but again, that they will meet with the DTIC and try and make sure this doesn't happen. The other thing that is important is that the DTIC are still going to be issuing permits for the exports of scrap. So they will have permits which will say, this is the grade, this is the value. They will also be part of the process of checking the value of the scrap and checking what is there before it is exported. So there's 2 levels of checks there, and we think, and SARS have assured us they can do it, and we do take their word for it and agreed for them there. I think what was the other, I'm sorry, I'm just going to quickly check the document. And then there was on abolishing the VAT on scrap and on container inspections. So the VAT on scrap issue is, it came up in a lot of our consultations with industry, but it is pure fraud. This is basically dealers of VAT creating fictional VAT inputs that they can then get a refund. So our SARS colleagues can talk more about it, but this is pure VAT fraud. SARS have been notified about it, and they have got information about that, and they will be looking into these entities to try and stop such a behavior, but in our mind, it is something that needs to be dealt with directly through enforcement, and it doesn't have a bearing on the export tax. And similarly for the containers and bulk equipment, bulkheads, SARS, are the ones who administer the tax, and I think they can look into those issues. The next one was on, Younger, do you want to start with tax exemption on employer-provided bursaries? Younger, are you there? Shall I go, or would you like to?
Younger?
I'm muted, sorry. I'm muted.
Okay, right, fine, go ahead, please.
Yes, as previously said, and also as said by the commentators on Tuesday, in 1992, this exemption of employer-provided bursary was introduced in the Act. In 1992, when it was introduced, it was clear that it should not be subject to an element of salary sacrifice. In 2006, changes were made in the Act and we removed the requirement of a salary sacrifice. And as commentators said that in 2006 EM, there was a view to say that there is a legal argument regarding the issue of salary sacrifice, but the issue of skills shortage still remains an issue in South Africa. That is in the EM, that was said by the commentators, and we are also repeating it today because we have to be true to what we said as a reasons for policy change. And in the draft bill that was published for public comment on 31 July, what happened is that in the budget, we said we have seen a lot of schemes. There is a question that has been asked that, where have we seen these schemes? Is there a revenue loss? What are the numbers? Yes, we have provided the numbers. Chris will be speaking on the numbers. What happens is that these schemes, similarly to other schemes that we see on tax incentives, these schemes, they are being advertised on the website. Now you can go on the website and say salary sacrifice bursaries. Mining Tax Review has got it to say employers, this is a smart way, employee bursary benefits becoming a good tax incentive. You go to Bean Counter, it's saying that helping your employees to save, structure your salary smarter. So what I'm trying to say that we see the adverts that are going around, of which we are also guided by other things as well. And then in the bill that was published for public comment, in the budget, we said the effective date will be 1 March 2020. Even before we made the changes, I just want to share with you to show Parliament that we are listening. Before we could even make the changes, we were receiving phone calls and people were writing to us to say that the changes cannot be retrospective to 1 March 2020, even though you've mentioned in the budget, based on all the issues that they put forward to us. When we published the bill for public comment in July, the effective date, we made it prospective to 1 March 2021. This implies that we took into account the taxpayers' comments even before the bill was drafted. Because when they write to us, we understood their comments to say, okay, you don't know how you're gonna make changes to the bill and yet you have a retrospective effective date. We all agreed that we can't have a retrospective effective date. Okay, in the draft bill, the effective date should be 1 March 2021 instead of 1 March 2020. So this is one comment also whereby we listened to the public even before we drafted the bill. So when we drafted the bill for public comment, we had 3 requirements that we put there. We said the bursary should be open to general public. There should not be an element of salary sacrifice. And if there is an element of salary sacrifice, then there's not gonna be an employer deduction. We received a lot of comments on that. And then on the bill that was tabled, we removed all the 2 tests, that is, it should be open to general public. We removed that test because we listened to the comments. We listened to the comments and removed the requirement that if there's an element of a salary sacrifice, there's not gonna be an employer deduction, even though the 2006 amendment, before 2006, it was like that. That is from 1992 to 2006, it was like that. We agreed with them to say that if there's an element of salary sacrifice, sacrifice, we cannot be punitive. They cannot be double punitive. So what happens is that it's not going to be an exemption, but it will still qualify for employer deduction. So what was left in the bill, there was only one test out of 3, and there was a prospective effective date instead of a retrospective effective date. So comments were raised, Chris, okay, yes, comments were raised regarding what we have said in 2006, and that it is contradictory, and that we did not provide numbers, and that they said that instead of removing the salary sacrifice, you make exemption dependent on 2 conditions. It should be paid to educational institutions, and the payment should be made directly. Next slide, Chris. When we are responding, we have to take note of what was there in 2006 and before 2006. As we have said previously, yes, we're not gonna say as we have said previously, but we can't go beyond that text, is that a bursary, a bona fide bursary, is something that has to be given by a person or an organization. So we are moving away from the 2006 wording to say that if there's an element of a salary sacrifice, it still qualifies, because we are of the view that the employer is not funding the education, but the employee is paying as a before tax. And that does not create equity to all other people who are not allowed to structure their salaries. Because what happens is that in the private sector, we can go and work for one company. We've worked in the private sector. My salary structuring can be different to the salary structuring that to the next person or next employee sitting next to me. So it does not say that all employees working in one company can receive one salary structuring. And also during our discussion, we were saying that it would have been nicer if employers, instead of the institutions that are doing these bursary schemes, it would have been nicer if employers were here in Parliament, so that the employers that have got a relationship with the employee and also can tell Parliament, why are they not giving these as bona fide bursaries? Why is there an element of salary sacrifice? Because a salary sacrifice you pay before tax, whereas if it is a bona fide bursary, you'll have your package of 1,000, and then on top of a package of 1,000, you will have your bursaries. That's what those are our discussions on the side as to why it will be nicer if the employers were here, because as Saika has said, it's an ideal situation to strive for, to have a bursary on top of the employee's package. Next slide, Chris. Also, we're of the view that the 2006 amendment, which made provision for exemption to apply subject to an element of salary sacrifice, create this unfairly distribution because those employees who are not allowed to do salary sacrifice, like other employees, like your self-employed people, your entrepreneurs, even your government employees, they do not get this benefit. So it's not like the tax incentive applied to each and every employee. The tax incentive apply because your employer agree. So it is still discretionary to the employer that the tax incentive should apply. Secondly, the 2006 amendments legally do not work, as it is legally arguable that a bursary that is subject to an element of a salary sacrifice cannot be regarded as a bona fide bursary. That is the other reason, because the minute you say, even though we said in the EM that we still want to do this, but the challenge we were facing with SARS when they were applying the law is that the law still referred to the bona fide bursary. So at no stage the law did not say bona fide bursary, even though in the EM we said that. But now when you apply the law to the latter, it still refers to the bona fide bursary. I think Chris will talk on the numbers on the next slide. Thank you.
Thanks, Yanga. Also, just to make another point on the funding, I see in the document as well, there's a point to say that by doing this, we're going to negatively affect funding of education. Now, in a salary sacrifice arrangement, I think it must be quite clear that the employer is not contributing anything more for education. So the employer is not funding anything more for the education, and the administrators that are administering the scheme are also not funding education. The only people who are funding the education are the individuals and the employees themselves. And by using a salary sacrifice arrangement, all that is happening is that the tax liability of the employee is going down, but the employee is still funding that, which begs a very important question on the principle, just before I get into the numbers. And the principle is that, private expenditure is not tax deductible. We can't spend money on our own security. We can't spend money on purchasing bedroom or TV and make it tax deductible. Private expenditure is not tax deductible, and paying for education for your family is also not tax deductible. It's seen as maintenance of your family. I think it's section 23. Younger can correct me. So if you allow and you explicitly allow a salary sacrifice arrangement, you're turning that principle around. And suddenly now private expenditure is tax deductible. And then every single formal sector employee in the country, if you explicitly allow this, would then be able to restructure their affairs and then get their education paid for by the employer, and then get it as a tax deduction. Now, there are over 10 million formal sector employees who have remuneration below 600,000 that this could potentially apply to. So you can see that the impacts would be incredibly large. In terms of the numbers that we have, we've got a table there. It's gone up to around 27,000 claims in the 2018-19 year. They claimed for an amount of about 568 million, according to the data that we have. And the revenue forgone was around 110 million. So this increased by about 180% in a period of 2 years. And it's much, much better to try and stop this now before we get to a position where it's explicitly allowed and it will then move through to all formal sector employees. And that is certainly not the principle or the intent of what we were trying to do with this original objective of this incentive, which was for employers who pay more, who pay an additional amount for their employees to get additional training, that those employees don't get a scary tax shock that they never expected because it is now a fringe benefit. In this case, it's just a rearrangement so that you don't pay as much tax. If we are worried about the tax positions of individuals at the bottom end, we need to do that through the structure of the personal income tax regime and others, not through these types of mechanisms. The next issue is withdrawing from retirement funds upon immigration.
Chris,
Momo, do you want to come in?
Yeah, I just want to make the point. So to honorable members, I think, the point I know, the thing about tax incentives is, in a sense, it's not a kind of right. It's a right that's given to a category of taxpayers over and above what others are paying. And so I think we just got to be mindful that part of our policy in the budget is to remove many of the current tax incentives because they work against equity in a sense. I think in this case is how do you fund private education and who gets the benefit? And I think, as Younger has said, it's interesting that the submissions are not coming from employers. It's actually coming from, mainly it appears, many companies who are the facilitators of these schemes and do administrative services. And obviously, what is their interest? Their interest is this scheme means that there's fees for those companies. Now, that's not a bad thing, but I'm just saying it's quite important to notice the perspective, I think, of the interest that, but when you have tax, I mean, we always try and figure out what interest does this group represent. Is it just for themselves, which is fine? Is it for a fee? Is it for parents who are sending their kids to these schools, etc., etc.? And I think just we are concerned about these types of adverts that go around and try and effectively sell a tax incentive scheme. for no real benefit. Benefit in a sense that people are already at those schools. It's not like a new productive activity. Rather, what it is just reducing the revenue in these hard times. But I'll stop there, Chair.
Points of order, Chair. Points of order. I'm sorry. That can't go unchallenged.
Order.
Chair.
What's the point of order?
Chair, I don't believe the source of a submission is relevant. It's whether the submission is valid or not. The source of it is irrelevant, and I think that we should. The last thing we should look at is where the submission is coming from. We need to look at the facts based on pros and cons. So I disagree with that, and I mean there's no law against advertising a tax benefit. You know. Yeah, I think that whole...
Yeah, but Dennis, you know well enough that's not a point of order. That's a view. Actually, you'll be surprised to know that I partly share your view, that it doesn't matter what the intent of the stakeholder is, it's whether it's progressive and it serves the interests of disadvantaged people. You're right. Momo is absolutely right to draw that to our attention because it's only fair. And you're absolutely right to say what you want to say, but it's most certainly not a point of order. So one recognizes both points. You can raise it further, Dennis, when it comes to the discussion. Momo, you have every right to say it. Can we move on, please? It's a policy issue. It's a view. It's not a matter of a point of order. Thank you.
Chris, you can go ahead.
Oh, sorry, I was muted. I was talking to myself. Thank you, Chair. The next one is on the withdrawing from retirement funds upon immigration. So, you know, we proposed this 3-year rule, which really came about because of, you know, we are modernizing the foreign exchange control system. We're moving to this new capital flow management process, which meant that we're going to get rid of this this very administratively burdensome process of immigration, which is recognized through the Reserve Bank, where you have to close your bank accounts, you have to say that you won't come back to SA for a number of years, you have to stop your loans, etc. We're going to stop that to make it easier for individuals to leave and come back so that they don't break ties with South Africa. But because we're getting rid of that, we're getting rid of the trigger for individuals who want to leave to then take out their retirement annuity fund. So we needed a new trigger. So we opted for a 3-year rule. A lot of comments are made to say, no, they shouldn't do it. People need this money to be able to move offshore. There's 3 years, there's nowhere else in the Income Tax Act, etc. Now, our view is that, these commentators aren't talking about the individuals who stay within South Africa and what happens to them if they want to get access to the retirement annuity funds. If you stay within South Africa and you don't leave, you have to wait until you are 55 years old, regardless. There's no other way for you to get that money. Whereas now for individuals who leave, we are allowing that they could be able to get those funds, but they do have to wait for 3 years. The point that while these individuals can't use that money to now, there's a lot of costs associated with leaving the country. They want to use those monies to then leave. Government did not provide a tax incentive for people to create funds to then have the resources to be able to leave the country. This is for retirement. It's a retirement tax incentive. There's no tax on the amount that got in, and there'd be no tax on the investment growth within there. On the point of it not being related to anything else in the Income Tax Act, using the trigger of immigration at the Reserve Bank was also nowhere else in the Reserve Bank. So it was also a standalone trigger. So this is also another standalone trigger that we don't think will have as many we think it provides the correct balance of equity between those who stay and those who leave, as well as making sure that the incentive isn't used for other reasons. I think I've covered those. Then there's amending the 183-day rule to the foreign remuneration in light of the 2020 travel ban. Yanga, I don't know if you want to come in, but I can talk about this. Yanga, do you want to talk about this one, or shall I?
You can talk about it. I was going to talk on CFERAS. That is the difference for Sharon between Section 10101 and Section 10102. For SAICA, the difference between the 2 years.
Okay, thanks. So we've reduced there's a 183-day rule in the Income Tax Act that if you work outside of the country for more than 183 days, from this year, you get 1.25 million Rand that is exempt. So you don't have to pay tax on that amount that you earn while you're offshore for more than 183 days. We recognized, so this wasn't in the budget, we recognized that people couldn't travel because of the lockdown and the travel restrictions. So we used the days in lockdown levels 4 and 5 and removed those to reduce it to 117 days, so that if individuals are outside of the country for more than 117, they'd be able to use the 1.25 million Rand exemption. The comments that we've got now after going to the Standing Committee and the NA are that the 117 is, they were grateful for it, but they said it should be lower. What about other countries that also still had travel restrictions so that they couldn't get into those countries? The problem is we couldn't create an amendment based on the different lockdown restrictions in every other country and knowing which individual here was based on those other countries. It would have been incredibly complicated. And we're not sure that we would have been able to administer it. I mean, there is quite a bit of relief in moving down to the 117 days clause. There is also DTAs that they can talk about. So some comments were saying that there still would be tax applying even if they worked here, and there would be a potential case of double taxation, because even if someone is working in South Africa but they're being paid from a foreign country, the foreign country withholds tax, but then they're also going to be liable for tax here. Where there are provisions in the Income Tax Act that you won't be actually faced a double tax arrangement, you can do that through 6 Quat and get directives as well, to make sure that those double tax doesn't apply. Do you want to talk about seafarers, Younger?
In the return submission, of which we decided to include them as one, there was an issue that this exemption is only made for Section 10102 and not to Section 10101. We wish to point out that this provision was made as a result of the COVID-19. And in our response document for the COVID-19, we said we're going to look at this during the TLAB. Not even a single time during the COVID-19 whereby the reference was made to Section 10101. The reference has been to Section 10102. And that said, the application of Section 10101 is different to the application of Section 10102 in that Section 10101 refers to crew members and seafarers. And unlike Section 10102, Section 10101, it's a complete exemption. There is no cap. We only introduced a cap of 1 million, which we increased it this year to 1.25 million in Section 10102. Thirdly, the Section 10102 exemption applied to a 12-month period, whereas Section 10101 refers to the year of assessment. What happens is that when it refers to the year of assessment, you look, it's not a 12-month period, you look at the whole year from 1 March 2020 to 28 February 2021. Now, the lockdown restrictions were lifted long time ago, meaning that people falling under the exemption in Section 10101, because you look at the year of assessment, the implications are different from Section 10102, whereby it's looking at any 12-month period. But that said, if now they are of the view that, because this is a new comment, that's what we are saying, because during the COVID-19 tax bills, we did not receive any comment referring to Section 10101. Because this is a new comment, we are still in the 2021 legislative cycle. So we urge taxpayers to file their comments in terms of the new processes for 2021 legislative cycle. Thank you, Chris. You can move to the next slide. And then slide 38, yes. What happens is that in the NCOP on Tuesday, comments were raised regarding the VCC tax incentive regime and the sunset date. Our view is that even though in the budget review we said we're gonna be doing a research and a survey to check if the sunset date can be extended or discontinued, that is the VCC incentive. We did not say this year, we said this year we'll be doing a review. Hence, it was not an oversight or an omission for the clause regarding the sunset date not to be in this TLAB, because that was not what was mentioned in the budget. As such, because there is a process, they said that we should start the process of doing the review. What happens is that we have started the process of a review already. On 31 July 2020, we published a survey on our website whereby we requested information from all VCCs that are registered with SARS. And the purpose of requesting this information is to do a thorough review based on the information which we received from them. And as we have said this year, we had so a lot in the agenda. There were COVID-19 tax bills and there were 2020 tax bills. So we received this information by the end of the closing date, but it is important to note that even taxpayers were asking extension for the submission of further information in this regard. And then we extended the submissions of the information. And then on 3 November 2020, we just want to highlight in Parliament that they said that we should start the process. Well, so now we have started the process. On 31 July, we published a survey. On 3 November, we issued a media statement saying that on 2 December, because now we've got all the information that we required, on 2 December, we are holding public workshops just to discuss the information received on the survey, on the VCC survey. Once because now, after we have received the comments, we analyze the information. So now we want public consultation process with the VCC just to discuss this information, so as to see what can be considered for the budget for 2021. And we wish to note that because during public hearings last week, the industry talked about certainty. What we want to know that in all the tax incentives in the legislation, the certainty has been provided. How is certainty provided in that? When we introduced the VCC legislation in 2008, we put the sunset date of 30 June 2021. So it was so clear that by 30 June 2021, the VCC, this is gonna come to an end. And when we're having our discussions today, just before the meeting, we were thinking that it's like going to buy an electric appliance or a car and you are given a 2-year guarantee. It is clear on that date, on 2008, it is clear on that date of making a purchase that there is a 2-year guarantee is gonna come to an end after a particular point in time. And the rationale for having a sunset date on all the incentives is that it is the issue of certainty that the taxpayers were asking. So in all the incentives, we have a sunset date so that there's an understanding that is taking place from this date to this date. And after that date, it's a sunset date and it can be reviewed for whether it can be continued or not. But certainty we do provide. Chris, I don't know whether you want to add on that.
No, thanks, Yangi. That was great.
Francis TALAB.
Great, thank you. Thank you, Chair, thank you, members. So the one item which got a fair amount of comment in the original rounds of comment and had one commentator in this particular round that the Select Committee has been conducting relates to the removal of the requirement to prove intent. I think we can skip through these slides because it basically sets out the background to why the change was made. This slide gives a sense of the changes that were made already. So there was a concern that we were introducing strict liability, which is something that you find in other countries. That is not something that is appropriate for South Africa. So we are not pursuing strict liability, and we wanted to make that clear, so that we have done. And then we also proposed a differentiated approach for the kinds of offences. So moving on to the next slide, there seems to be a perception that what we're doing is unconstitutional. That is simply not correct. If you look at the case law, what we are doing is constitutional. And if you move on to the next slide, you'll see it is done in many other statutes. And in fact, after the Constitutional Court case that has been cited in many of the submissions was decided, and which we submit supports our view, a matter on the use of negligence as a standard for an offence went to the Supreme Court of Appeal, where the Supreme Court of Appeal had no difficulty in finding that negligence was in fact an appropriate basis for the offence. I'd just like to emphasize here that we need to understand what this means. So essentially, it's a reasonable person standard. So we've heard a lot of submissions in the past and one again recently, where the comparison is made to an honest mistake. Now, if you're looking for a quick summary, we would propose a different one, which is negligent or unreasonable non-compliance. Why unreasonable non-compliance? Because if you have taken the steps that a reasonable person would have taken, then this simply doesn't apply. And one of the key safeguards for any member of the public here is that the onus of proof is on the state here. So it's not for the person to demonstrate that they took reasonable steps. It is for the state to demonstrate that they did not. And once the state has made a prima facie case in that regard, is only then that the person needs, or sorry, I'm actually restating that incorrectly. It's only once the state has shown that beyond reasonable doubt, that it is up to the accused in this case to demonstrate that there is in fact a reasonable doubt. And that is a very high standard of proof. Now, if we move on to the next slide. Now, one of the comments that's also been made is, well, these are all minor administrative things. What's the problem really? And that sounds attractive at face value, but it's not if you look at it carefully. So for example, well, why is it so terrible if I don't notify SARS of a change of address? Well, the fact of the matter is many of our collection steps and other steps require us to in fact serve notices on you at a particular address. If we don't have the correct address, that process falls apart. So having the correct address is in fact very important to SARS. Failure to appoint a representative taxpayer. So in the company context, a public officer. So what's the problem if there isn't one of those? Well, if there isn't one of those, then you don't have a person who's responsible for the affairs of the company. So now what? And so we can go on. I've looked at all 4 of the examples that were given. And on the next slide, we look at the next 2. And really, one of them shouldn't have in fact been in the list because that particular offense is in fact in the higher, stricter standard one. And neglecting to make a document available, again, sounds innocuous at best, but it's the taxpayer who has control over documents. It's the taxpayer who knows what documents exist. And so SARS is largely to the mercy of the taxpayer when they ask for information. So again, if there are key documents that are not disclosed, there is a serious problem because transparency is key and fundamental to the administration of a tax system. And just to make one more obvious point is Metcash in the Constitutional Court made the proposition that we, in fact, compliance by taxpayers is crucial for effective revenue collection and will necessarily entail a measure of policing by the authorities. And I think that's something that needs to be taken to heart. So moving on to the next slide. So now the proposition that has also been made was, well, why don't we simply rely on administrative penalties here? So I think it's useful then to have a look at an example of a case where there are administrative penalties, and we then see how effective they have been. And so we have administrative penalties for personal income tax and corporate income tax returns if they are not filed on time. And an interesting feature of those penalties is that they increase for every month that the default continues, up to a maximum of either 36 or 48 months, depending on whether we have an address for the particular taxpayer. So again, address becomes important. So with that in place, what has the result been? Well, as you will see from the SARS 2019-2020 annual report, which was recently tabled in Parliament, filing compliance really isn't anything to write home about here. And the debt book in respect of unpaid administrative penalties is growing. So it would seem that the administrative penalties, whilst they may be assisting us, and we have some work to show that they do internally, are not a sufficient deterrent in and of themselves. We need something more. And prior to the introduction of the Tax Administration Act, we had that something more. And what we're proposing now is to reinstate the something more. Moving on to the next slide. Finally, we have a comment that we get to choose who to prosecute. So that's a misstatement, actually, because really the issue here is who can we investigate? Because we need to investigate people. Once we've investigated, we can build a case. Once we've built the case, then we can hand it over to the NPA for prosecution. And as the euphemism would have it, we are in a target-rich environment. There are many, many tax offenses occurring. So what we need to do is we need to prioritize to get the best impact on compliance. And that means we probably need a mix of prosecutions so that people know that we are touching the various aspects of tax offenses and know that we are monitoring it and that there is a serious downside to non-compliance. And so, unfortunately, we do not have all the resources we would need to do a very wide spectrum, but we certainly can prioritize, and we do so. So any suggestion that we should investigate and lay a charge in respect of every offense, even if we restricted it to the most serious offenses, would still be a stretch. And so this need to prioritize and to investigate and prosecute in order to get maximum compliance impact is something that we need the power to do. And other investigatory agencies in South Africa with a broad ambit have precisely the same problem and have to approach it in the same way. So we are subject to oversight. If we move on to the next slide, it's very clear that if SARS is acting with an ulterior purpose, that is not permissible. The Supreme Court of Appeal has been very clear on that. And ultimately, the NPA and the courts are a check and balance on SARS to ensure that we are doing things right. And I think I'll hold up there. Thank you.
Thank you, Chair. We have finished. We have finished the oral submissions. Now we are coming to the written submissions, Chair.
Fine, please do.
Okay, Chris. With the written submissions, we're gonna do individual companies and then international tax and VAT. The first one on individuals is amendments made to Section 32BA and 33 of the Estate Duty Act. In the 2020 TLAB, amendments were made to delete paragraph BA of Section 32 of the Estate Duty Act and to place this paragraph under Section 33 of the Estate Duty Act dealing with the provisions of deemed property for estate duty purposes, as it was incorrectly included under the section dealing with the property. During the public comment process, we received comments on this. And then now the comment that came in together with the return submission was that SARS should amend the Rev 267. The return must allow the executor to separately declare these amounts as deemed property. We wish to state that the comment regarding changes to Rev 267 were raised during the public consultation process. And we said that this is an interpretation issue that does not require changes to the legislation.
Younger, we are not as technically sophisticated as you. Can you explain Rev 267, please?
The Rev 267 is the return that is submitted for estate duty purposes, Chair. So our view is that changes are not required to be made in the legislation. If there are any changes, we can make it in the return. Thank you, Chair. The next slide. And then there were further comments that came in on Tuesday to say that it should be clarified that the section applies to actual contributions made after 1 March 2016 and does not include deemed contributions. And secondly, the above may be the intention, but there is no clear reason why Section 10C has been left out of these provisions. We wish to state that these are the new comments that have never been raised before. And we understand the comments regarding the clarification issue. And because these are the new comments altogether, we urge the members to submit comments if there are further changes required to be made in the legislation in terms of the Annex C process. We are dealing with the Annex C 2021 legislative cycle.
Okay, can I get some clarity on process? When an issue, when you're saying that this is a new submission, are you saying it was not raised in the NA?
We say, Chair, this is a new submission. It was not raised during the public comments on 31 July. It was never raised during the public hearing. So it's not like we never listened to them. They never raised.
So in other words, this issue, to answer the question precisely, was not raised in the NA.
It was never raised in the NA, and it was never raised in the public consultation process with Treasury.
All right, now hang on. Let me just get some clarity. Frank, can you help us out here? I mean, surely if this is a new amendment, a new proposal, and it wasn't raised in the NA, and it's a Section 75 bill, all we can do is mention it in our report. Can we do anything about it? Frank, are you here?
I'm here, Chair. I'm audible, and can you see me? Chair, I would agree, because
I can.
You can propose amendments on a 75 bill. You can consider it, yes, Chair, but it hasn't served before the National Assembly, so or before the Standing Committee itself. So it's going to be a total new thing for the Standing Committee. And what the Constitution requires of a 75 process, well, Chair, if I understand the Constitution correct, you can look at other areas of the bill. You don't just consider what the NA has done. You can actually consider it and say that there's more that the NA must consider, and it goes back to the National Assembly and then the Standing Committee. Do I make sense?
Can I suggest, would it be, yeah, well, can I just get clarity for our purposes, right? So given the lateness of the hour, given that the NA did not look at it, while recognizing that we can refer them to look at this issue, given the complexities of the issue, can the committee decide, or can the chair rule that this issue goes to our report? It's not for policy decision making. It can be looked at in the next year.
Yes, of course. Of course.
And it would not be regarded as violating any rule or constitutional duty we have.
No. I mean,
yes, well, I'd like members to think about this. Yanga, can you tell me how many of these issues are raised for the first time in the NCOP? I do think even if we can do this, it is not political wise to do it. Not with a 75 bill. Let them decide. We will note these things in our report, all the new ones. But can I ask you, Yanga, are there any other proposals to amend now with the NCOP that were not there before in the NA and are not related to issues you dealt with at the NA?
Yes, Chair. I think altogether there are about 5 or 6. But we've said.
Can we just note them? Can we note them? Remember,
so this is the second new one.
Yeah. Okay. So then you don't have to go through it exhaustively. Can I suggest, based on what Frank has said, and based on what I've said, Esther, when you craft this section of the report, bearing all this in mind, can I suggest, members, that we don't say yes, we don't say no to this, because there are bigger policy issues here that we want to win the NA over towards, if necessary, if we agree on these proposals. Can we agree that we forego all the new ones, the 5 new ones? She can just note them and we don't discuss them and take a decision on either now or next week. So can we hear Dennis Ryder on this, and then Moletsane, and then Fanny Jutoy?
Yeah, Chair, I think let's hear what they've got to say. I don't want to preempt anything, so let's hear what they've got to say. But if they're brand new submissions, I think it's probably right that we note them. If there's one that makes a big material difference, we may want to react differently. But I think
I agree with that. Yeah, I should have qualified that. No, I agree with you. Actually, I should have qualified and said, if they raise something new, Frank, that's substantially a big policy issue and it's really convincing, then in that case, I think we should, do what we think is necessary. But in general, like this one, I mean, really, this we can just note. Okay, Esther, you're here on the platform presumably, and you're noting all of these things. Okay, go ahead. Yeah, go ahead and just note to us which ones are totally new. Okay.
Thank you, Chair. The next one is addressing the circumvention of anti-avoidance rules for trust. In 2016, we introduced anti-avoidance measures in the Income Tax Act, capping the tax-free transfer of wealth to the trust using the low interest-free loans. Now, we have seen that taxpayers are now implementing new variations of structures whereby they are not using loans, they are subscribed to preference shares with no or low rate of return in a company owned by a trust in order to benefit from the tax, in order to get a tax benefit in this regard. So in the 2020 TLAB that went out for public comment, we made the following changes. We inserted a deeming provision to say that the subscription price of preference shares issued will be deemed to be a loan, because now they are no longer doing loans, they are issuing preference shares. And now we said, in addition, any dividend in respect of those preference shares shall be deemed to be interest. And then we made changes in the TLAB based on the comments received. So now we received this comment. This is not a new comment. The proposed amendment will apply to preference shares issued by companies, the shares of which are held by trust, and will force dividends to be declared annually at a rate of at least equally to the official rate of interest. This treatment will apply even if there was a genuine commercial reason for the issuing of preference shares. Our response to this is that these rules will apply when an individual is transferring assets to a trust through the use of companies, free of tax. So we are not introducing new measures. So during the workshops, we asked, what are those legitimate business transactions? We did ask that question because we said that these rules will apply when individuals are transferring wealth to a trust, when you issue preference shares. So, and then it is tax-free. So if it is a legitimate business transaction, we did ask those transactions and nothing came forward. So we are of the view that, Chair, that we did ask for the legitimate transactions that the companies can get to, and then we never received a response since we did not make changes in this regard. The next one, Chair, refining the interaction between the anti-avoidance provisions for intra-group transaction. Currently, the South African tax legislation does not have group taxation, but we have got company reorganization rules from section 45 to section 47, 41 to 47, whereby we allow tax neutral transfer of assets between the companies within the same group of companies, and the same group is 70% in this regard. Because we are giving a tax neutral transfer, we have anti-avoidance measures so that people do not get to benefit whereas they do not qualify. So in the TLAB that was published for public comment, we made changes to the law regarding the interaction between these anti-avoidance measures, because we were told in the 2020 Annex Chassis process that the interaction between these anti-avoidance measures is creating unintended consequences. And then the revised TLAB that was tabled by the minister, we took account all the comments received, but there was one comment which we did not take into account, and it is this. Intra-group transactions that have reached the 6-year anniversary do not benefit from the proposed amendment and therefore are prejudiced, despite them not triggering the degrouping provision. It is recommended that the proposed provision be expanded to include intra-group transactions that have reached the 6-year anniversary. So there is an understanding on this comment that we did what we said we're gonna do in the budget, because the proposal in the budget was limited. There was no expansion. So during the public comment, we took into account of this comment, we take this comment into account, and we said, because we are constrained in the TLAB to give effect to the proposals that are mentioned in the budget, Proposals that are not mentioned in the budget, we cannot do. So we said this can be considered in the 2021 legislative cycle because it's expanding this provision beyond what is mentioned in the budget. The next one, Chair. Clarifying rollover relief for unbundling transaction. As we have said, we've got corporate reorganization rules from section 41 to 47. And then section 46 deals with unbundling transaction. Next slide. In the bill that was published for public comment on 31 July, we made changes to remove the reference to the connected persons test in this rule. And the comments that we received were like, by removing the connected person test, we are making the rule more punitive. It will be difficult to monitor and all that. And then in the TLAB that was tabled by the minister on 28 October, we made changes based on the public consultation process on 10 September. We had separate meetings with the taxpayers after the public consultation process, as we normally do if we want to iron out issues on 23 September in this regard. And based on those public consultation process and the separate meeting with the taxpayers, we came to an agreement that instead of removing the connected person test, we have to change the whole provision to get the provision altogether and insert the provision that was there before the changes were made in 2007, whereby we said that the rule will not apply to disqualified person holding at least 5% of the equity shares in their unbundling company immediately before that unbundling transaction. When the bill was published for public comment, the effective date of this proposal was 31 July 2020, which is the date for public comments. Based on the public comments received, we were told that because now you are changing the legislation altogether from what was there during the public comment, then you must revise the effective date. And then we did revise the effective date to say the effective date of this provision, because this is an anti-avoidance measure, will be 28 October 2020. That is the date of the tabling. So we moved the effective date to 28 October instead of 31 July, which was there. So now the proposal that has come, the comment that has come from SAICA is that the proposal affects live transactions and not all transactions that will be impacted will be done with an avoidance intent as considered. It is therefore unfair to treat them all the same with retrospective effect. Therefore, the amendment should apply to unbundling transactions that are entered into after the date of promulgation of the 2020 TLAB. We wish to state that because the effective date was 31 July 2020, we did take into account the comments received from stakeholders and we moved the effective date to 28 October 2020. That's all, Chair. Chris, can you please do the incentives?
Thanks, Yanga. So we've also did an amendment in the TLAB where we were trying to provide more clarity on the sunset date for the SEZ tax regime. There were some questions saying that, you know, at the moment in the law, it says 10 years from the carrying on of a business. We changed it to 1 January 2031. And they're saying now, well, this is going to provide some, it's going to undermine confidence and it will shorten the length of the incentive that companies are able to claim. And there's some confusion over whether they could still use the accelerated building allowance or not for this incentive. We've looked at this, you know, we wanted to put a hard sunset date on this incentive. If you had it for 10 years from carrying on a business, it could have applied from, I think it was 2030 or 2029, and then a business could start the carrying on of a business then in 2029, and then it would run up until 2039. You know, we've put a view in the budget this year that we are trying to put more sunset dates on incentives. We don't believe they are equitable. We're not sure that they're actually providing good value for money. We'd rather have lower tax rates overall for everybody than particular incentives for specific businesses from a tax perspective. So we put that view in the budget. This was part of those mechanisms where we are trying to clean up this incentive program. By having a final 10-year program, 10-year period, it makes sure that investors, if they want to use this incentive, they must come in now. They must come in earlier. They don't have to wait until 2029 in order to get their businesses going. They should try and come in as soon as they can to try and claim this incentive up until 1 January 2031. It will also avoid the position where we have some firms that were early starters in the SEZs that would then run out of the incentive after 10 years, and then later firms would come in later, and then they would get the incentive for a much longer period after that, and they would then be more competitive than the early starter in the SEZ, which is also not very equitable. The building allowances, we also would like to state that, in the way it's written, is that you can only claim those up until 1 January 2031. So you can't continue claiming those accelerated depreciation amounts after that. We encourage firms to come in as soon as possible to make use of these. Younger, do you want to talk about Reits?
Okay, the next comment is on Reits. In the 2021 legislative cycle, 2020, we did amendments to Reits tax dispensation by clarifying that to provide that non-equity shares must be specifically excluded from the shares that must be listed on a recognized exchange for purposes of Reits special tax dispensation, because the intention was only to make provision for equity shares. We've got comment from SICA to say that the proposed amendment still does not appear to prevent a REIT from issuing preference shares. We wish to note that in the 2020 TLAB, draft TLAB, amendments were only made to section 1, definition of a REIT. But after we received public comments, we also made amendments to section 25BB to take into account the comments that SICA is raising. So we wish to state that the comment that SICA is raising now has already been addressed in the 2020 TLAB that was published in our website on 28 October 2020. The next one. We also received comments from the Reits Association to say that the effective date of any amendments to Reits tax dispensation included in the 2020 TLAB should be delayed due to COVID-19. We wish to state that the 2020 tax bills give effect to the tax proposals mentioned in the 2020 budget and do not take into account what was mentioned in the COVID-19 tax bills. And we wish to state that if now taxpayers feel that we have to delay some of the tax proposals or tax amendments due to COVID-19, we wish to state that they have to make those comments for the 2021 legislative cycle. The next slide, Chris. Also, this was the comment from the Reits Association. In the 2020 TLAB, we made amendments to Section 11J and Section 11JA of the Income Tax Act to clarify the tax treatment of doubtful debts for taxpayers conducting leasing business and applying IFRS 9 for financial reporting. The effect of this amendment is that taxpayers applying IFRS 9 for financial reporting purposes are allowed to claim doubtful debt allowances in respect of lease receivables that have accrued to them, not in respect of future leases. So this amendment is helping taxpayers. The effective date, now the comment that we are receiving is that the effective date of this proposed amendment should be made retrospective. Now they are requesting retrospective effective date because this amendment is assisting the taxpayers and they want it to be 1 January 2019, that is as from last year. Our view is that during the public comment, we received the comment that the effective date should be looked at. Yes?
Younger, can I raise an issue about process, right? So
Yes.
You've exceeded by far the time allocated, but I've allowed it because it's a much more comprehensive and very useful reply. And we want to thank you and the team for the very detailed reply, and we're really grateful for that. But I'm worried about time because we have stakeholders here who want to reply. And I would like to suggest that you move a bit faster because some of the issues you're dealing with, I think, are minor. I'm not saying they're not important to the stakeholders, but minor compared to the big issues. We will have to meet again on Tuesday to finish the process. So I would suggest that can we allocate 5 more minutes, please? Because remember, the members will not be able to speak. We have to close at 20:30, but before they do, our members, we have to hear the stakeholders respond to you, right? So having said all that, can you round up in 5 minutes, and then we can come back. If the stakeholders raise issues which you haven't covered, then you can take us through the relevant slide. So how about 5 minutes? Can you do it? Finish in 5 minutes.
I'm gonna finish in 5 minutes. I think the bigger issue, and then because France has got one on the TALAB, it's amendments to section 9D, that is slide 88.
Right.
We wish to state that NASPAS, because that is the company itself that made comments here.
Yes.
In slide 88.
Right.
Yes, what happens is that we made amendments to section 9D so as to take into account the liberations of exchange control, modernization of exchange control. And then amendments were made regarding loop structures. So we received comment from NASPAS saying that the proposed amendment is punitive for South African corporate investors that own CFCs that will invest via those CFCs into South African companies. This is one of the new comments, because now NASPAS is coming with a new structure that maybe it has come out now after these proposed amendments. And then that's why we wish to say that they should put those comments to the 2021 legislative cycle. Can I hand over to France, please? Thanks.
So this is one of the 5, right, that are new, am I right?
Yes, Chair. The other ones is like section 92K, which is minor, but the NASPAS one is big because that is the only company that made submission, Chair.
Okay.
Thank you, Chair. I don't think we need to stay too long on this particular slide. There was a request that we notify taxpayers of requests for information, which has been thrown into additional focus because of the estimated assessment amendments that we've proposed. So our response here is that previously this used to be something that you could elect into in the SARS e-filing system. Obviously, some taxpayers didn't. Now, with our redesign, one of the projects that we undertook here was in fact to make this automatic for all taxpayers. We do still have some technical problems because some taxpayers don't give us up-to-date addresses, and we come back to that theme yet again. So clearly we can't help them. And we understand there may still be some edge cases where there is a problem here, and we're inviting the stakeholders that raise this to engage directly with us to see if we can resolve those technical issues. And I think I can stop right there.
Is there anything else you want to say? Okay, I'm having endless problems with, I've explained to Nkululeko, with the charger from my iPad. It was 100% and now it's almost zilch. And charging it in this room is complicated. But let's not bore you with that. I'm unfortunately challenged the way I haven't been for a while. So, okay, comrades, colleagues, can I suggest that instead of asking all of them to reply, the stakeholders, let's take it issue by issue. Then those who have done their bit, if they feel they want to leave, that's fine. But, you know, we're going to now allow the stakeholder to speak. Then to be faster this way, National Treasury replies, and then we say what we think for now, bearing in mind that we still have to have our respective study groups where we discuss our policy issues in preparation for Tuesday's meeting. But we can continue this discussion on Tuesday, and we might have to look for another slot, but let's see how things go tonight. Okay, so on the excise duty on tax issue, where, you know, the tobacco tax issue, we've heard last week, this week Tuesday, both sides as it were, and now we've heard Treasury. So does anybody, if you're on the platform, want to comment on that issue?
I'd like to comment, please.
Yes, who would you be? Just mention who you are and who you're representing. Yeah.
Sure, my name is Samantha Philby, and I'm a research officer at the Research Unit on the Economics of Excisable Products.
Ah, yes, you were here on Tuesday. Go ahead, yes.
Yes. So basically, something that interested me in Christopher's presentation was that when he was speaking about export taxes on scrap metals, he alluded to the idea that there are certain trade agreements in place that South Africa has to comply with. And I just wanted to reiterate that in South Africa, we have ratified the Framework Convention on Tobacco Control, which is an international treaty governing things like tobacco taxation. And so we're obligated under that treaty, much like we are obligated under different trade agreements, to implement excise taxes that make cigarettes less affordable over time. So we strongly support the idea of increasing excise taxes. We appreciate that you have been nuanced about it, noting the complications of things like illicit trade. But just in terms of illicit trade, it's important to note that the tobacco industry has systematically been increasing its net of tax prices of tobacco products. This was over the period from about 2000 to 2010. And an increase in the net of tax price of tobacco products increases the price of tobacco products. But a tax also increases the price of tobacco products. So why does the one cause an increase in illicit trade and the other not? That's just a line of economic reason that simply doesn't make sense. So we appreciate that illicit trade is a problem, but we mustn't take it with as much seriousness as the tobacco industry suggests. Thank you very much.
Okay, members, do you want to raise anything before Treasury comes in? No? Is there any other stakeholder? I take it there's no other stakeholder because nobody's asked. Yes. Oh, you're here. Okay, go for it, my friend.
Yeah, Chairperson. I think, thank you very much. Good afternoon.
Oh, sorry, Mr. Njalo, can we just hear Mr. Ranji, please? Yeah, he's coming in. Yeah. Let's hear Mr. Ranji, and then you can come in. Yeah. Yes, go ahead, Mr. Ranji.
I will speak about heated tobacco products, not about cigarettes. I'll be very brief. I think on the 17th of November, when Treasury gave the briefing to this committee, they made the case as we have made for net, because what was said is that if a producer makes a lighter weight heated tobacco product, less tax is going to be paid. So that's the area for manipulation that we are highlighting with the current system. And that is why we have said that if you go on a net tobacco weight basis, case that I made the other day, doesn't matter what shape or form the product comes in, SARS and Treasury can be assured that for every single kilogram that is consumed through heating, that the exact same amount of revenue will be achieved. Now, when the written response was given to the Standing Committee on Finance on the 13th of October, it was also stated by National Treasury that they intend to move away from the current system, which they've clarified for this year is going to be based on the full weight of the tobacco stick. They perhaps going to scrap that and go to a system, they cited countries Hungary and Jordan, where there's a fixed rand and cent amount per stick that's going to be paid in terms of excise. And what we would also like to do prospectively and now in advance is highlight that there are some issues with a system like that. Just take, for example, a very simple scenario, just for ease of exercise. Imagine if somebody produces a much bigger heated tobacco stick that can be used twice, but the excise is levied simply on a stick basis. Then effectively, somebody that makes a longer stick that can be used twice, 3 times, or maybe it's not even a stick, maybe it's a pod, maybe it's something different because this is a new and emerging category, they're going to pay less tax. They're going to pay half the tax, maybe even less. So I think the ultimate point that we are wanting to make now is to say, please can we be consulted in the process prior to any announcements in the budget speech in 2021. When the announcement was made in the budget speech this year in February, we, as players in the heated tobacco products category, were not consulted by Treasury. We accepted the announcement which came from the minister that the tax would be implemented. We were given a heads up that something like that was going to come, but we weren't consulted, so we weren't able to experience in multiple jurisdictions around the world. And I think that if we are given the opportunity to really go through things in immense detail, and a setup like this doesn't allow for us to really go into the detail, we may be able to highlight the pros and cons of the different systems which are implemented around the world. And there must, again, with respect, be a reason why so many jurisdictions around the world have chosen to go on a net basis only for the tobacco in these products, so that you have a common denominator and the revenue and SARS can be assured of the amount of money that they're going to get. But also from our perspective, we then know that there's a level playing field. So we don't have to compete with people that are going to be able to manipulate the system by changing the
No, I think your point's been made. Okay, Mr. Ramji. Okay, fine. So Treasury, just come back and then we will. Okay, sorry, Mr. Njadu, you had something you want to ask quickly?
No, Chair. I think let me come after.
Okay, let Treasury come in. Yeah. Okay, colleagues, remember that the research team has done some background work and has got some questions to ask. National Treasury did reply to most of those questions, but nothing stops a member, if you're not satisfied with the answers you've got, to put the question again and add to it. But now, having said that, can we move to National
Sorry, Chair,
Treasury?
before National Treasury,
Yes, Saka wants to come in on this. Okay, listen, I can't manage a cell phone, an iPad, and constantly looking at the what's hands raised thing. Nkululeko, can you just tell me who wants to speak on this issue quickly? Then I can allocate time evenly. We're running out of time. So, firstly, how many other people want to speak on this?
I've got only Saika from stakeholders. From members, I've got Mr. Njadu and Mr. Ryder.
Right. Now, can we have a system here? Because no other committee does this, as far as I know. I would like to suggest that unless you have a stake in this issue or you've previously commented on it, you don't come in, really. But if you insist on coming in, you'll have a very brief. Mr. Ramji is right to take the time he did. But Saika, can you be brief? What is your issue?
No, I'm responding to the three issues that we raised. So I don't know if you want to finish his issue first. Let National Treasury reply on his issue.
Of the tobacco tax, the excise
I'm fine.
Can
Thank
we
you.
have, right, we'll come to you later, Sharon. Okay, very quickly, what's up, members? Dennis, you want to say something? Mr. Njadu, you want to say something?
Yeah.
Is that correct?
Yes, correct.
Mr. Jadu's foregone. He's right. At the moment, he wants to get Treasury. Mr. Dennis, do you want to speak now before Treasury replies?
Yeah, I'm really not sure.
Somebody said Treasury reply. Give us a holistic picture, and then it's easier for us to get a balanced view. Don't you think it's better just to ask National Treasury reply? Then you and Mr. Njadu can come in.
Okay. Can we come in then, Chair?
Is that okay? Right, fine.
Yes.
Sorry.
Yeah.
What I'm suggesting, colleagues, you decide, right? My view is let's hear Treasury reply to Mr. Ramji, and then we come in having heard both sides twice. That's fair. That's what we normally do. But sometimes one adjusts, one's not rigid about it. So can't we go by, given the circumstances and the time, can't we just allow Treasury to reply? Then comes in Mr. Njadu and Mr. Ryder. How about that? Good. Let's do it. Treasury, quick. Right. Reply, please.
Thanks, Chair. Just quickly, I mean, on the tobacco and illicit trade, you had noted, I don't think the FCTC is ratified yet. I think NDOH is still working on it. On the price, we didn't say that we are moving to a stick in the document. We said that we're considering moving to a stick per basis. So we are looking at all the different options, recognize that there are, whichever way you do it, some products might be slightly more taxed or others. It's a new category. These are new products. They've all got different ways of trying to come up with something that's consistent and equitable across, and we will continue working on that. Thanks.
And Chair, if I may just come in, I think we don't consult anyone before we make tax proposals. They are welcome to submit their proposals. We've heard the argument, but the minister then makes the announcement. We don't consult anybody on any tax proposal beforehand to say, can we do this or we intend to do this. These things are market sensitive, so they are free to submit any documentation before for our consideration for any budget announcement.
Fine. I was going to say that when I was rounding up my view. Mr. Ramji, that's not the done thing. If they consult with you, then they must consult with all the other stakeholders that are relevant. And then Parliament will be subordinate. And in elected politicians and the departments that serve the ministers, ultimately, as you are, the decision makers, having heard everybody. Now, can we have Mr. Njadu and Mr. Ryder? think you are muted, my friend. Yeah.
Okay. Yeah, thank you very much, Chair. Chair, on I think in terms of the responses, one would just want to check on maybe some of the issues were raised in the responses. So, but one want to check in terms of the proposal. How would the proposal, which is amended, ensure efficient application of the text legislation? So in terms of a question, then the 3-year waiting period, in terms of practical and technical challenges for taxpayers.
Jadu,
Yes.
I think what we're doing right now, as agreed, because of the nature of this exchange and the limited time, is that we're looking at issue by issue. So you can raise your issues when we come to them. On the matter of the tax on tobacco, do you have any outstanding issue? As for the next set of issues, when we come to it, you can certainly come in there. On the matter of the matter before us now, are you fine with that? Okay, Dennis, are you focusing on this matter that we're dealing with now?
Yeah, very briefly, Chair. And yeah, first I was just trying to clarify the process because your microphone fades in and out at times as you move closer and further away.
Yeah.
No, I understand it's unusual, so I wasn't sure the process. But just a quick question on the tobacco issue specifically, and it's to Chris. Chris, you said the exclusion of the word net was not a mistake. The point is that 28 other countries have said they will include net. You didn't really tell us exactly why the exclusion is not a mistake. You kind of hinted at it, but you didn't give us a firm comment. Why is it a conscious decision to exclude the word net? I think that's the crux of the whole argument is it net, is it not? Give us in one sentence that even I can understand what was the conscious decision behind that?
Yeah, you know, Chris, I was going to ask in a different sort of way the same thing. I know I asked this question on Tuesday, why are you going, why are you not going with the majority of the countries? Not that because other countries go for a particular option in tax or anything else, we should do so. We have specific circumstances. You did reply broadly, but again, I'm just want to understand better, having heard both sides. What is it? Okay, why is it? Can you explain clearly? I agree with Dennis. Answer the question, please, precisely.
Thanks, Chair. So if you look at the final result, the important thing here is what is the final impact, the final tax that you actually pay when you do it without doing it on a net basis. If you look at a normal pack of cigarettes, it's 17 Rand that you pay on a normal pack of 20. What we were trying to achieve, what we said was we would tax this at a concessionary rate of 75% of what a normal pack of cigarettes tax would be. And if you look at and you use this kilogram basis, you get to a value of around 13 Rand, which is close to 75% of what a normal pack of cigarettes is. So that was why, and that was how we got to that point. It is, we have done it, you know, these are new products, we are going to refine it, but that was the basis, and that's why it wasn't a mistake. That was what we were trying to do. We're looking at the final tax that's actually paid on these pack of 20s. Thanks.
Okay, so Dennis, I believe you're accepting what he said. Is that right? That thumb up is meant to mean that. Is that right?
I'm noting what he said.
Right? Sorry? What did you, I'm sorry, man. I don't know what, I've never seen that before on a Zoom virtual platform. Was it a thumb up or did I imagine it?
It was a thumbs up, and I said, yeah, I'm noting what he says. That's perfect.
Yeah, okay, fine. We're not taking any decisions, DA or ANC or anybody. Simply, comrades, colleagues, is there any matter of clarity you want to get? No.
Hi, Chair. I've got Mr. And Mr. Muletsane.
Yeah, Mr. Muletsane. Yes, my brother. Come in, please, man.
I'm on the issue of the bazaars. I'm not sure whether should I wait until...
No, my friend. Yeah, we're coming to that. Okay, so on this matter, I must say this is totally new to us, okay? It has been very interesting and challenging. Hands up those of you who understand these issues. So at this stage, I think we want to allow the political parties to discuss this further with the respective researchers, for me as a chair of the committee to engage with the team that's applied to the committee, and for us to, do further work. We can't sit here endlessly debating the issue. So, Mr. Ramji, thank you very much for your input. There's nothing further we can do at this stage. Please understand, all stakeholders, we're not going through the motions. We don't have to do this. So why do it and then pretend like you're serious about it? This has been done since 1998 in the committees I've served. And you know what? Finance didn't do this before we got here in 2014. You can ask Dikeledi though. Oh, by the way, Dikeledi is in an urgent meeting of the ANC PEC where she's at. And I said, it's fine because we're not taking any policy decisions on which she'll have a say. Okay, that done. Now, sorry, yes, who's that?
Okam has his hand up as well.
Oh, good. Okay, Okam. Oh, Dikeledi is back. Oh, I thought you were in the PEC. Okay, fine. Yeah, okay. So, Dikeledi, you can come in as and when you feel like it. Now, Mr. Willie Okam, quickly, please, what's the issue?
Thank you, Eunice. No, Eunice, I have been covered in certain part by what Dennis Ryder has asked. I just want to get clarity also on the tobacco thing, because apparently, as I understand it, the normal packet of cigarettes was based on the weight of the tobacco in it. And the packet of heated tobacco are based on 75% on that, but it's not 75% of the tobacco in the heated product compared to the tobacco in a normal cigarette. I still do not understand that question, and maybe Treasury can enlighten us on that. Thank you so much.
Again, Willie, never mind, we are ideologically worlds apart. The same thing occurred to me. I didn't want to detain the meeting. I thought I'll get Esther to clarify that, and if need be, ring Younger and Chris and them and get answers to it, and then come back and report to you. Because where I exchange with the officials, if they're giving answers, it's my duty to report back to you. But if any member wants to ring them and ask the question mandated by the committee, hey, it relieves me of the pressure. I was going to ask exactly the same question, so you might as well deal with it now, Chris. You see, I thought about it long before Willie did, so Willie's tailing me. I'm not required to prove anything, Saika, before you raise your issue. Right, fine. Go for it, Chris, please. We're running out of time, my friend.
Thanks. So the normal cigarette, it includes the filter and it includes the actual paper. It doesn't just include the tobacco, it includes the whole weight of the actual cigarette. So that's why, thanks.
Really? What's your cake?
Really? That is why I asked the question. Thank you for the answer. We need to get the information. Thanks.
Okay, now you saved me some time. Okay, good. Thank you, Willie, for once. Now, can we go on? That was facetious. Can we have the next issue, export taxes on scrap metals? Anybody wants to come in here, the stakeholder, please? Mr. Ramji, you can leave because we're not discussing this issue again. On Tuesday, the party political positions will emerge, if not Tuesday, on Wednesday, or whatever time. But Inkululeko Mangweni, our excellent secretary, will keep the stakeholders informed, but we will not now. We'll move into the formal process from Tuesday. So quite frankly, we're not going to entertain any comments at this late stage. Thank you. Can we move on now to the export taxes on scrap metals, please? Inkululeko, is anybody wants to come in? Inkululeko, can you intervene and say so-and-so wants to come in? Or can the stakeholders say, excuse me, chairperson, and then I will allow you to speak. Go for it. Who's where?
I don't have stakeholders as yet. I've got members, Mr. Ryder and Mr.
Fine, then let's go to Mr. Ryder and Mr. Dutoy. Once we finish, there's no stakeholder. National Treasury doesn't have to reply. Over to the two. What's the point of these people making something disappearing? Here. I mean, we're giving them a chance to participate. And if somebody says a stakeholder, Martin Friedman.
Yes.
Yeah, come in, Mr. Friedman. Mr. Martin, I can't read very well from this distance. Go ahead, please, whoever you are.
Good evening, Mr. Chair.
Right, go ahead, my friend. Yeah, go ahead, please.
My name is Martin Friedman. I am the CEO of Cape Gate, a steel and wire manufacturing company based in Vanderbijl Park. We have a significant interest in this issue as we are probably the biggest scrap consumers in the country. We have made various written representations regarding the export tax, and my concern, I'll state it as simply and as quickly as I can. Originally, in order to achieve the objective of making scrap available to the local industry, ITAC was tasked with coming up with the PPS system. my memory serves me correctly, that was in 2013, and it's taken us 7 years to get the PPS system amended to such an extent that we now think it actually aids all of us in achieving the government objective. We are now looking at replacing the PPS system with an export tax, and it is our belief that it might take us another 6 years to get the export tax system amended to such an extent that it achieves the government's stated objective. There is no doubt that allowing a straight percentage tax, as well as allowing the exports to take place in containers, that it is going to be fraught with all kinds of circumvention mechanisms, and it's going to take us a period of years to close those gaps. So my concern is the PPS system is now, in my opinion, fairly effective, especially with the latest proposed amendments, and we're going to change it to a tax, which from our view, from industry view, is going to be fraught with a whole lot of loopholes that are going to take a long time to close. Thank you very much.
Yeah, that was raised by other stakeholders on Tuesday and in the NA. Over then to Treasury before I bring in the members.
Just on that point, I mean, you know, the reason of going to an export tax, which was supported by a lot of people also in your industry, was that the PPS was not effective. And they wanted a different mechanism. They were saying it wasn't working, it didn't get the objectives that it was trying to achieve, which is why, you know, we've agreed to move to this new system. I think obviously there are going to be teething issues because it is a new system, but we will see how it goes. And it's, I don't know, it comes as a bit of a surprise to me that it's now, why aren't we moving with the PPS, when the majority of participants that we spoke to about this before was actually, this is a move in the right direction. Thanks.
Okay, Momo, do you want to add anything? Yanga?
I just want to add that, as Chris has said, this was a proposal that we discussed with ITEC, moving away from PPS to export tax. So hence now it comes as a surprise that the question that is being asked, because this proposal, and it has been consulted widely by both ITEC. ITEC made its own consultation process and then they received their written comments. But even us as Treasury, we made our own consultation processes for tax purposes and we received comments. Thank you, Chair.
Anybody else wants to reply from the National Treasury?
Yeah, Chair, let me say, sorry if I may come in. Look, we have said that this, Chris did say right at the start that the export tax hits different players differently in the steel market. So, you know, it may be that for some firms, it will hit them obviously differently, negatively, and some positively. And I think we've tried to take a balance of all the views. And we have some flexibility that if the system has some perverse outcomes, the minister does have some powers which Yanga can outline. But like Yanga and Chris have said, generally the view has been that the PPS system is failing. And yes, it's still a challenge to figure out whether the export tax system will work better. But on the PPS, it's the first we've heard of anybody saying that it's actually achieving what government wants it to achieve. Thank you, Chair.
All right, so basically what you're saying is that the PPS system, it's consensus or substantial consensus, is not working. And you're exploring the export tax issue. You have some loopholes or some latitude to see how things go and change things. And then if need be, you'll come back with an amendment to Parliament. That's what you're basically saying in a crude, over-condensed way. Am I right?
Yes, currently, Chair, as Momo has said, in the draft TLAB, there is a provision that we have made in the customs and excise duty, whereby that provision is there in terms of all the excise acts or customs duties to say that the ministry
it's a general, yeah. Okay, I think we know that. Yeah.
Reduce any export duty imposed in terms of this paragraph.
Yeah.
So what happens is that in terms of notice in the Gazette, so we have put that provision in the bill.
Okay, now, Mr. Friedman, you know, in this area of our work tax, I said this on Tuesday, one of the most interesting things for me, and I'm speaking subjectively, but I'm sure many others agree with me, is on almost every amendment Treasury makes in good faith, and the Parliament supports it, sometimes across political parties. What we find is people are always looking for, ways out and abusing it and so on. And it's like almost endemic to this area of work that we do as parliamentarians. So it's something they themselves recognize may happen, and there's some sort of safeguards, if you like. Ultimately, I think what we should say in our report is Mr. Friedman raised this issue. The committee feels that it came quite a late stage. It goes, if Treasury is correct, Esther, you got to check all this, your Parliament, check that this is correct. I'm not saying anybody's lying, but it's from different vantage points. We are Parliament. We're not saying anybody's, Mr. Friedman or Mr. Momo and his team are doing anything wrong. We as Parliament are independent. Esther, can you look at this issue? Engage with Treasury offline tomorrow morning. And then when we meet at 1 o'clock, we want some answer that we can give back to the committee. So we can note it in our report, and then we commit to, together with the NA mainly, it's their responsibility primarily, to monitor this over the next few years and see how it's going. So if it doesn't work, Mr. Friedman, you write to us, give us the evidence, not us, write to Mr. Joe Maswangani in the first instance. It's a 75 bill. And then if you're not happy there, you can come back to us. But really, that's your option. At this stage, I would like to suggest we move on. Mr. Friedman, you have every right, as Mr. Ramji, to write to the committee, preferably at this late stage, no more than a page, to argue your case yet again. Esther and I and the others here will have a look at it. We'll forward it to the members. And on Tuesday, we'll emerge, on Tuesday and Wednesday maybe, with our final positions on it. But remember, colleagues, in the report, we can signal our unhappiness, or we can say we didn't have enough time, but we let it pass because it's 75 bill, etc. And Frank is going to assist legally to manage that wording. Okay. Having said that, there are members who want to speak. Who is it in Koleleko?
It was Mr. Ryder and Mr. Detroit.
All right, go for it, Dennis and Fanny.
Thanks, Eunice. Look, I'll be quite brief. I think that my evaluation of this is that the inputs from the stakeholders are largely more things for the DTI to consider.
Yeah, I also wondered about that, Dennis. I wondered about that, yeah. On Tuesday as well. Correct, yeah.
I think massively valuable inputs, and started to get an understanding of an industry that I have no knowledge about. And I do think something important is emerging here, but I'm not sure that it's SARS's problem to fix this issue. I think it's got a hell of a lot to do with the DTI. And I think that what I'd like to hear from SARS is a commitment that they will engage with SARS on this matter, because this issue of scrap and under invoicing and the difficulty of quantifying, evaluating is a big one. And it's opened my eyes certainly the last few days to this. So I think that SARS needs to
area, yeah, correct. So you mean DTIC? So yeah, good point, Dennis. Okay, SARS, France. What's your response to Dennis's suggestion?
So, Chair, I mean, we have been engaging with the DTI. Yeah, this is where it comes from, and we would obviously continue to engage.
Yeah, what we could do, Dennis, if you feel strongly about it, maybe we can refer our observations to the DTIC committee, or at some stage, I don't know when, if we find the space, the two committees can look at this issue. I don't think within the first year. Let's look at it later, maybe towards the end, well, not in the following year, whatever, if we're still here. If COVID-19 hasn't evaporated the entire universe, given what's going on at the moment in the northern countries. Right, over to Fani.
Thank you, Chair. Chair, I had to, no, in my previous life, I was involved in the steel industry for quite some time. And my experience is that the steel industry is under tremendous strain and has been under tremendous strain for quite some time. And ESCOM played a huge role in that. I know that National Treasury wants more money in the state purse, and that is one of the reasons why the export tax should be higher according to them. But we must also keep in mind that the import tax was also increased over the past few years, and the cost of manufacturing in South Africa also skyrocketed with the minimum wage in the metal and engineering industry. Chair, my question is, with the export tax also increasing now, what effect could this whole cycle have on steel manufacturing as such in South Africa? Will this not put a bigger strain on the manufacturing side and basically cause a retraction in manufacturing and export of finished goods in the country?
Yeah, that too, funny, I thought about on Tuesday, but didn't raise. That's a fair point. Can we have a reply, please, National Treasury? Chris?
Yes. Chris, do you want to do it?
Okay.
No, I'm not quite sure. You can go ahead.
Okay, I was gonna say that the impact regarding trade, this is what ITech is doing and monitoring in terms of the ITech app. So I think hence is saying that communication with the DTI, because the trade impact, that's what ITech monitors, hence the increase in import and export duties. Maybe Momo?
Do you want to add, Momo?
Chair, I mean, I think it's incorrect to say that the Treasury is imposing this for revenue reasons. If you look at all the reasons we've put out, we've outlined the challenges with any export tax. This thing has been solely driven by ITech and at that time EDD and DTI. So, and you know, we've as Treasury, I mean, also just challenged them on their reasoning and so on at some point. But this is the position we have. It's been a long process to get this. And yes, there won't be total consensus. I don't think that's possible. But but it's certainly not been put there by Treasury for revenue reasons. And it is the trade issues that are coming through. And the impact on local manufacturers, foundries, and so on, that has been driving this position from DTI.
Okay, you've covered yourself and the team quite well. Look, Mr. Friedman, you can write us a few lines, maybe up to 10 lines or so, about how you feel, having heard everything. And we will consider, the committee will decide. I suggest we just include your concerns, a National Treasury's reply, and say, okay, we'll observe this issue. Having said that, can we move on to tax exemption of the employer-provided bursaries? Right, smart funder and the like. You want to say anything? In Kulileko, is anybody here wants to speak? Mr. Liebenberg here. Go ahead, Mr. Liebenberg.
Thank you very much. Honorable Chair, thank you very much once again for the opportunity to speak tonight. I apologize if my response isn't very elegant. As we just heard the arguments from Treasury, I've written down a few things on paper, but I'll try my best to keep it coherent. So also thank you to National Treasury for putting forward the responses. We definitely welcome them. It's a discussion that we think could have been very fruitful if we could have had it earlier. Before I dig into the responses here, I'm going to respond on most of the issues raised tonight, but I just want to briefly pause and just remind everyone that even though we are going to talk about technicalities here today, the main point that we've put forward is that there's been decisive action to put forward an incentive, which is very clear in law, and that there's been a further incentive for people to further the uptake around this. Honourable Chair, the Honourable Prince Zolani Mkiva asked a question in the previous session on the split between rural and urban. I just want to briefly respond to him on that because we've gotten the facts on that. So Honourable Mkiva, 46.7% of the users of this incentive are from rural areas. It's places like Matabetule, and then close to home for you in the Eastern Cape, Kumbu, Uluyisu Primary, Lebode, Riverside Primary. There are numerous rural areas making use of this. Then I also want to make just note to the committee that National Treasury still hasn't responded to the question raised in the Standing Committee on what the benefits are on this. It would seem that it's very much a discussion just around the numbers, but for us, these are not faceless ledger entries. there are real faces behind this, which are ordinary citizens from a lower income or part of the population who make use of this. On the issue raised tonight and the comment made by National Treasury that this is only available to the private sector, not to the public sector, just a quick comment on that. We've been approached by parastatals such as SAA and ESCOM, and we're in discussions with them to help them and to assist them to offer this to their employees. From a state point of view, various municipalities are in discussions with us. ICASA and even SANAS have also approached this to help them administer this incentive. So it's certainly not something that's only available to the private sector. The public sector certainly could benefit from this. It's obviously just a big administrative task to administer this, and this is why organizations such as us exist. On the point of why it is an organization such as us and EdInvest sitting in front of you here tonight and not employers, the perception has been created that the employers themselves have no interest and have not made submissions. But Honorable Chair, I think in the interest of transparency, I also just want to highlight to this committee that in the session that National Treasury had, the workshop, employers, employees, I mean, who are the parents who utilize this, even schools made submissions. There were over 100 submissions. There was participations by stakeholders across the board. And there was even a single mom who participated in the workshop and spoke and shared her success stories of the benefit. And she mentioned how she uses the tax saving to put this towards saving for a child for further education after school. So I just think in the interest of transparency, it would not be fair to say it's only us as administrators who are here, but National Treasury are welcome to say if I'm wrong in that statement. The question was also asked tonight, what behavior is incentivized by this? So if there's a salary sacrifice, the funds are foregone, it's committed. You cannot salary sacrifice something and then get the funds back after you've done it. If you salary sacrifice a part of your salary, it's gone and it's committed to the school. So the behavior that is incentivized is the payment of school fees. Similar to how tax-free savings would incentivize saving, this incentivizes the payment of school fees. Now we can report, and once again, we are happy to engage on this because as the administrators, we have the data on this. But even during COVID-19, we had less than 0.1% of people not paying school fees through this. So once you've committed, it changes behavior, which is obviously the goal behind any incentive. And then, as I've mentioned earlier, employees use the tax saving to better the education of their children. So we have examples and testimonials of employees telling us that they've put their children in schools closer to home because they can afford it because of this. They put their children in aftercare. As I mentioned earlier, some of them even use this to save for further education. So moving on to the issues that were discussed in Treasury in the slide deck, was made tonight that this is not a right. Now, this may be the case that it's not a right, but from our point of view, even though it's not a right, it's something that was explicitly made available to the general citizens to use. I've just put three things here that I'll touch on, and I'll be brief. On the matter of whether this can be a bona fide scholarship or bursary, I'll convince you with my words. So once again, I've drawn up, this is the words from 2006 in Treasury, where in 2006, bona fide scholarships or bursaries. This talks about nothing else than bona fide scholarships or bursaries were not tax exempt if there was a salary sacrifice. The change made only looked at bona fide bursaries and scholarships, which after the change were tax exempt, regardless or not whether salary sacrifice was present. So if you ask the question, can a bona fide bursary be granted on salary sacrifice? One has to wonder, what was the change in 2006 after all, if not to allow for, in Treasury's own words, bona fide scholarships and bursaries granted on salary sacrifice. Okay, so that's the response on that matter. We think that's very clear and obvious. On the matter of salary sacrifice itself, the comment was made that salary sacrifice is not accepted under, would not stand up in a court of law. So I've drawn in from case law on this, and I want to read for you out of a court case. which says, it is not uncommon in practice, employers and employees are entitled to structure salary packages as it suits them, and they are entitled to do so to achieve maximum tax acceptance. It is accordingly quite lawful for an employee to sacrifice salary in return for some quid pro quo from the employer, which has the effect of reducing the tax liability. And then further, in this court case listed here, it supports it. But further than that, remember that the citizens of the country can only act on what the authorities put forward. Now, I want to quote from the SARS Income Tax Practice Manual itself that says, salary sacrifice schemes will not be subject to attack. But then it goes and it says when it won't be, provided that these arrangements are reflected in an agreement, preferably a written one. And this is the tone behind what we've been saying all along, is even in the SARS manual, it says what the conditions are for a valid salary sacrifice. And the point that we want to make is, you cannot say that it's not justifiable if there's case law supporting the justification, but rather, why do we not firm up the requirements that would make this justifiable? And then on the last point, from a loss to fiscus point of view, it is very good to see the numbers put forward by National Treasury on that. Honorable Chair, you mentioned that our numbers probably won't agree, and we knew that would be the case. But I just think it's important just to give a brief explanation on how National Treasury and SARS views these numbers as they are submitted. So there are IRP5 codes that employers, which are the companies, use to report on any bursaries or scholarships that are issued. Where the bursaries are non-taxable, the IRP5 codes that they report on are 3815 and 3821. So these codes, and this is the important thing to note tonight, these codes that are seen by National Treasury and by SARS do not distinguish between normal bursaries or salary sacrifice bursaries. So salary sacrifice and non-salary sacrifice is not distinguished in the numbers that are reported. Secondly, there are bursaries that go to employees, and there are bursaries that go to relatives of employees, which is what this entails. They are all reported under the same codes. So the question then comes up, the numbers reported by National Treasury, could be good to understand how National Treasury has gone about to determine which of the numbers reported was for salary sacrifice for relatives, which we are discussing tonight, because it would seem as if those are the total bursary numbers reported. And then lastly, the comment was made that there's been a considerable increase in uptake over the last 2 years, and it's been attributed in the comment tonight only by aggressive marketing. But I want to just once again remind the committee that over and above allowing for salary sacrifice in 2006, National Treasury have actually gone and further incentivized uptake by lifting the qualifying thresholds in 2012 to 2013, again in 2016, and there was a very large lift in the last 2 years. So the counter argument may also be that the considerable increase in the last 2 years was because this incentive is achieving exactly what National Treasury has intended for it to achieve, and that the considerable increase in the last 2 years, one would logically expect that if you have more people able to qualify for this incentive, that there would be a larger uptake. And just to conclude, once again, the main point that we want to put forward, and we should never forget this, is that if you had to explain to a member of the general public that before 2006, this could not be done on salary sacrifice, and after 2006, National Treasury put forward legislation to allow it, and further incentivized it by changing limits. If our rationale for taking it away is that we don't think salary sacrifice or bona fide is justifiable, I think that would be very, very difficult to explain to the names and faces of a vulnerable piece of our population. Thank you very much, Honorable Chair.
Thank you. Have Treasury reply, and then questions, comments from the members. Right, Treasury, quick, please.
Chairperson, I've got
sorry.
as well.
Sorry?
And member. I've got
Yes.
one stakeholder invest and member,
okay.
and Mr. Muletsani.
Yeah, leave the members out for now. We've agreed on the process. Can the stakeholders speak? But given that you're covering the same issues and the latitude given to Mr. Liebenberg, who largely presumably shares your views, I really can't allow, well, we can't allow, not me. It's now 8:09. I can give you 3 minutes at most. You can write to us if you're not happy with the time. Go ahead, please. You can
Perfect.
put your...
I'll use two. Thank you, Honourable Chair. So number one, thank you very much to Treasury for sharing the stats with us. I would then like to apologise because the stats that we have put forward on our page number 6 in our presentation is vastly different. And I would just like to ask Treasury to let us know in future, where can we then obtain these correct numbers if they're not from the tax stats as published by Treasury and SARS. Number two, I just want to talk to, I think it was Chris or perhaps Honourable Momo who made the statement. What is the purpose of the service providers? And I'll say this very quickly. We are a service provider because we identified a gap where we could provide a service. And if you look at the explanatory memorandum of 2006, you will see that they've explained it very, very good in there, where they said a salary sacrifice as a component of the exemption creates unnecessary difficulties in application. And I think Chris said it a bit earlier, that government wants to move away from these administrative, burdensome tasks that we're trying to make easier. So that's why us as a service provider actually exist. And number three, this is the last point, and then I'm done. This is the most important. We are helping an employee named Sandile Bolani, who works for Chamberlain's, who is able to spend almost half of his annual salary to get his children educated. His eldest son was, his dream has always been to go to a culinary school and to become a chef. And he this year spent half of his annual salary to get his eldest son a culinary degree and his daughter to get her through higher education. And when we spoke about the tax saving, the legal tax saving that he's getting from this incentive from government, I asked him, what are you going to do with this extra money in your pocket? And he told me, you know what, I'm going to go home and talk to my children and we will decide as a family what to do. Thank you, Honourable Chair.
Presumably, you spoke to the gentleman concerned that you were mentioning this in the public domain. Is that correct? Because you mentioned his name and his specific circumstances.
I will confirm that, but I'm almost 100% sure we have that in writing, but I can confirm that and get back to you.
Now, what I'm trying to say is I don't necessarily need that, but presumably there's a slight ethical issue. I mean, you give people an opportunity, you argue, to have their families educated. Now, if you mention a specific name, presumably you've consulted with him to say, look, I'll be mentioning you this evening at the Standing Committee, Select Committee on Finance.
I did not do that. I have consulted with him on previous occasions for testimonials, but I did not inform him that I will use his name.
So he has been mentioned in the public domain before.
We did ask him if we can use his testimonial. We've got other people's testimonials on our website, not
All
his.
right, so it's in the public domain. Okay, fine.
Yeah.
Okay, Momo on your team, come back on this, please, and then we'll hand over to the members.
Yanga, do you want to start? Shall I start?
You can start, Chris, with the numbers. I can add on regarding the interpretation of the court case official. I think it's the law.
Yes. Okay. Thanks. So thanks. Yes. So for the numbers, I mean, if you read the slide, we don't state that this is revenue forgone from salary sacrifice or another measure. We also don't break up the difference between is it for the exact employee or the relatives of the employees. We just say it's the total. So it's the total claims of 500 million from 27,000 with revenue forgone of about 110 billion. We also don't say that this is because of aggressive marketing or salary sacrifices. We say this is before aggressive marketing or salary sacrifice schemes. The numbers are different in the tax statistics because the tax statistics only looks at ITR 12 forms. As the one stakeholder mentioned correctly, it's all the information is in the IRP 5s, which we have access to, but we don't actually publish that table in the tax statistics. There was a very interesting question on the behavior change. Now, the original objective of this exemption was to encourage employers to contribute more for the education of their staff and the relatives of their staff. So that if they contributed more, it would be a fringe benefit in the hands of the employees, but then because it's exempt, that employee then won't have to pay an additional amount of tax. The behavioral change here that is spoken about is, I'm not quite sure what it is. It's about that individuals will continue to pay their school fees. So normally in an incentive, you're trying to get a new or additional investment, additional behavior or something. In this case, you could have parents who are paying school fees. They're paying school fees like they do at the moment, but now they go through a salary sacrifice arrangement where the employer does not pay anything extra to contribute to the school, but they go through a salary sacrifice arrangement and they get a reduction in tax, even though they're paying the same school fees that they would have paid before, but they're getting a reduction in tax. Now it's, and it's nice to hear the stories about these people who have additional income and what they do with this additional income, but it's very similar to if we were to reduce the personal income taxes for everybody, and then everyone would have reduction in income and they'd be able to save for their child's education or save for other things. So we've got to be quite careful about that. And what is the actual behavior change? Here, it looks as if you're going into a salary sacrifice arrangement just to reduce your tax. We also didn't say that we are against salary sacrifice agreements. Or, that's perfectly fine. But if you get a reduction in your tax from it, that's when we need to be worried. I've spoken about the data. The other thing we're talking about, these are low income employees. I mean, we must remember we're in an incredibly skewed income distribution in this country. If you're a taxpayer, you're in the top 20% of the country. If you're earning 600,000 upon where this actually comes to a limit, you're right in the top echelon of the highest incomes in the country. So I know we keep saying it's lower income individuals that we help, and there are lower and middle income individuals who do pay tax. But if you are, and you're lucky enough too, you are in the top 20% of the country. We've got to keep that as a perspective as well. The biggest thing for me really is this fundamental principle though, about it's a private expenditure. The only thing you're doing, the employer is not contributing anything more for education. The institution arranging it and doing the administration is not contributing anything more for education. It's a private expenditure that is now getting a tax deduction. If this goes through, it can literally be allowed then for the entire population of formal sector employees. And then if it is for the informal sector employees, why not for everybody else? What about the self-employed, as Younger was saying earlier, and others? Then everybody should be getting a deduction for paying their school fees. And I don't know there are many countries in the world who allow private expenditure to be tax deductible. We will have a huge knock on our personal income tax. These figures are very small at the moment. They would be immensely larger if we were to overturn this principle. Thank you.
Who's next? Younger?
Thank you, Chair. With regard to the bona fide bursary issue and the case that has been cited here, there is a view that the court case said salary sacrifice is okay if it's a quid pro quo from employer. So those are the words that he has omitted in that thing that he showed on the screen. But that said, yes, in 2006, we said in the EM, bona fide bursaries will be allowed the salary sacrifice. But that has not gone through to the law. Hence, we are saying that if SARS can apply the law to the latter, because the law is still referring to the fact that bona fide bursary is not regarded as a salary sacrifice. Thank you, Chair.
All right, members, who wants to come in?
Mr. Ryder and Mr. Muletsani.
Right, go for it.
Yeah, I'm afraid I...
You can go,
Mr. Okay, go ahead, Mr. Muletsani. It's fine, go ahead.
Okay, thank you, Chair. On the comment, I didn't hear any clarity about the beneficiaries of the employees, whether they are taken care of in totality, whether the bursaries are covering all the needs of the education. For an example, the tuition fee, the accommodation, the food, and the learning material. I just want the clarity on that. Thank you, Chair.
Thank you, Comrade Muletsani. Mr. Ryder.
Thank you, Chair. I'm afraid I'm probably going to take us way past 8:30 on my inputs on this because I feel quite strongly about it. but I will try and be as brief as I can.
Please.
I think this is, we all heard that the Lord giveth and Kieswetter taketh away. I think this is more a case of Gordon gaveth and now Kieswetter's taking away. But yeah, on a lighter note, Mr. Liebenberg, I think if you look at the public sector, they get paid way too much to fall within the limits of what we're talking about today. Mr. Liebenberg, before I get into my inputs, I also think that if you can submit that tax manual insert, I think that was your strongest argument of the day. So you flashed it on the screen and went past quite quickly. I do think we need to see that again and apply our minds properly to that. It was quite important. So, Chair, thank you very much. I think that there's a couple of issues that I want to touch on. Firstly, and Mr. Mamoniat and I seldom agree on anything, but I think we agree today on one issue, and that's the transparency aspect of the submissions. And I think that it's important for us to understand when matters have been brought before the National Assembly before in their form and when these presentations have been exactly mirrored between the two committees. I think it is important, and I agree with Mr. Momo that we should be informed of that. Having said that, I don't think that lobby groups should be limited in their lobbying. It's normal that lobby groups will run around and talk to everyone that will listen to them, and I think that's entirely normal. Public participation is absolutely valid, and we are two separate houses. We may come to different conclusions, but I do think it's useful for us to hear that a presentation has been made in the same form before. So we're definitely in agreement. Chair, getting to the point at hand, and I think that it's an ideological argument that needs to be interrogated quite carefully. And the Freedom Charter, I believe, sits behind this issue. And I think that we need to take into account that there is an ideological perspective to this discussion we're having that really needs to sit with. So let's have a look at the issues. In 2006, there was a clear, conscious decision to change the law to include the salary sacrifice. It was a concession made. There's a salary, there's an incentive, there's a tax incentive that's been introduced. Now, why was that tax incentive introduced? And one needs to look at the situation with education in South Africa at the moment. Government can't afford to build more schools. We need people to start paying more to look after their children's schooling, because there's a fair amount of no-fee schooling, there's a fair amount of low-fee schooling, but we need people to start contributing towards the education of their kids themselves. And the reality is that progress in this country is dependent on education. Progress all over the world is dependent on education. And without that, assertion, we're not going to go anywhere, because government can't afford to educate the people like it needs to. We can't afford to pay for new schools and schooling. We're stymied at the moment. So we need to encourage people to start funding their kids' own education a little bit. And I believe that is why this concession was probably made in 2006, because government accepts the fact that it can't be solely responsible for the education of South Africans. Incentive introduced. The fact that that incentive gets advertised is neither here nor there. The aggressive marketing, the fact that institutions are created around us, doesn't matter. You've created this incentive. SARS itself should be advertising the fact that there's an incentive. That's the purpose of creating an incentive, is for it to be used. So aggressive marketing, I dismiss that argument straight away, and that comment. Now, Nyanga made a comment about, they agreed not to be retrospective. So we must take that Treasury's made concessions. Well, agreeing not to be retrospective with this is nothing to brag about, because I think that would have been found to be illegal. So I dismiss that argument as well. The fact is that there are limits in terms of the incentive that's been granted. Now, Mr. Liebenberg, I think, has misinterpreted one of my comments in the chat. But the fact is that Treasury set those limits, and Treasury's increased that limit up to the 600,000, which may have been too aggressive. Okay, but I think Mr. Liebenberg's slide showed clearly that there was a progression from 250,000 income to 400 and 400 to 600. That 400 to 600 may have been too aggressive an increase, and so reducing that that limit may be something that I would be more willing to consider at this stage. But to do away with the whole incentive shows an ideological change from 2006 to now, which I do not believe that Treasury or SARS has motivated effectively to me to get my agreement on it. We're talking about an ideological change. It's a big change. It's not just a small thing. So Treasury saw fit to increase those limits. Now they're uncomfortable with it. So, what's the issue? Do we do away with it entirely, or do we drop that limit back down? So let's talk about the effect of what that'll have. So if you do away with this concession entirely, or this incentive entirely, what's going to happen? What's going to happen is that a new employee entering into a business is going to turn around and say, hold on a second, before we even get into discussions, I've got kids at school. I want to send them to private school. So let's talk a bursary first before we talk about my salary package. So will you provide a bursary? The company will say yes. Okay. And then the employee or the future employee or prospective employee will agree to a lower salary. So what we're effectively doing by suddenly bringing in this change that Treasury wants to bring in is saying that people that are existing employees can't benefit from this, but anyone coming in new, you've got the potential to benefit from something here. So salaries can be structured accordingly, provided that the employer says, no, we'll do a bursary. So you were talking about equity, and that removes the equity from the whole situation, because now you're advantaging new employees over existing employees that may have a track record of employment. So I think that the impact of changing this thing so dramatically is really going to create a situation of inequality. I also don't believe equality or equity is as far as concerned, but the thresholds that were put in place imply that there was a targeted group. This was aimed at getting to a specific group of people.
Mr. Ryder, you're going on for
Yes,
especially long, given where we are. The thing is that, remember, we are not finalizing the matter here. What we need to do is hear the stakeholders. And many of the issues you raise can be raised on Tuesday. So you can raise them. I'm finding them very interesting, by the way. Actually, some of them overlap with my own concerns. I've allowed you that latitude, Dennis, because in my view, at least, and I think to some extent, it's in Jadu's view, this is the biggest challenge we have. It is very difficult for us to be sure what to do. So, you'll have plenty of time to engage with Treasury. Now, it's important for Treasury to respond to the stakeholders, but also respond to what you're saying. Now, I have engaged with Nkululeko. We can have an extra 15 minutes, but there's also Saika's issues and so on. So we'll have to carry over some of these issues. Nothing stops the Liebenbergs and the lady from Ed Invest to be here on Tuesday, but, the space for them to speak again, well, now it's for members of parliament to decide. So can you round up in the next 2 to 3 minutes? Shorten your question, be more pointed. Then you can expand on them on Tuesday. That's a committee meeting, no problem. Let's finish this here.
Absolutely.
Right.
Perfect.
But you're making good points.
Thank you.
You're making good points. You're making good points, yes.
Thank you very much. So I will run up quite quickly. I want to say that Chris and I normally agree on many issues, and unfortunately today we disagree on almost everything or just on this specific headline event. The fact is that education is not like buying goods. Education is something that government is invested in. So it's not like normal private expenditure. So incentivizing someone to take on the burden of educating their own kids is actually shifting a little bit of the burden off the state. So it's not the same as normal private expenditure. And there were a couple of other arguments, Chris, that you made that I really wasn't comfortable with.
No, you can respond to him on Tuesday in regard to that, yes.
The point that you put in there about the fact that, we didn't say that, we kind of said this, you implied it. Let's be very honest with each other. But that's fair enough. Thanks, Jay. I'll leave it there.
No, thanks, Dennis. That was helpful. Right. Over to Treasury. But before we do, Nkululeko, can you tell me who else of the stakeholders needs to come in? Now, I know Saika has to come in. And then who else is here dealing with other issues apart from those we've done and will do in a moment. Who else is here? Stakeholders.
I've got Saika, Mr. Ban, and
Who's that,
S12.
Mr. Barnes?
Yes.
And S12. Wow.
Yes.
You know what? We're in trouble here because the Parliament doesn't allow you to go beyond 3 hours. And, you know, we're already at 3. We can extend it for 15 minutes, but no more. So, you know, this is a virtual world we're living in. It does mean flights and so on. And there's no obligations. Frank, am I right? There's no requirement in terms of the rules. As far as I know, we initiated this in 2014, this dialogue thing. I think Momo will confirm it's never been done before. So we're not forced to do anything. We've done our 3 hours. But you know what? Let's be fair to those who have not been having a say. So in that case, I suggest we deal with this matter, deal with Saika, and then draw to a halt, provided we can do this by 2045. So the second thing is those who have not been attended to, Mr. Barnes and S12, they can connect on Tuesday, but they're not needed necessarily. If they want to, it's fine, but we can't do better. I don't know how to chair a meeting that's as complex and as challenging as this one. Maybe you need a better chairperson who can manage this in 3 hours. I can't. So let's move on now. You know what? I suggest, National Treasury, you respond mainly to the stakeholders, and where it overlaps with Dennis and Moletsane, fine. Otherwise, Dennis and Moletsane have to be in any case on Tuesday for the meeting. You can reply in fuller detail to them. But both of them make very good points. So we'd like a full response to it. And maybe you can do that on Tuesday. Just deal with it in 30 seconds in each case. Focus more on the stakeholders. Then we will go to Saika and see whether we can squeeze in their responses or they can connect with us on Tuesday. But there's nothing further I can do. 2045, we have to stop promptly. Right, over to you, Treasury.
So just quickly on those comments. I mean, the one is, government can't afford to build schools, so we need to incentivize. But if we're giving a tax exemption for individuals to spend money on their children, even going for private schooling, there will be even less money available for expenditure for government, for those on the real low incomes to increase basic education department expenditure, etc. There's a point that we've created the incentive and now we've increased those limits. We actually increased those limits by quite a dramatic amount from quite strong suggestions from the Standing Committee in the last couple of years. And that was really to incentivize employers to spend more on educating their staff. So those amounts were increased so that employers, because government doesn't have as much money as you say, for employers to spend more. A salary sacrifice arrangement doesn't do that. To do away with the whole incentive shows an ideological change. We're not doing away with the incentive at all. If employers spend more, the incentive is there. It'll still be a tax exemption for those employees who get it if employers actually spend more on helping to train their employees. Thank you.
Who else from Treasury?
Treasury? Just wanted to say, yeah, I can see the point about insinuating about the revenue and the things. Yes, thank you.
Anybody else? Momo, Yanga, Franz?
Thank you, Chair. We wish to point out that the incentive is not taken away. When, as Chris has said, whenever an employer provides a bursary, the incentive will always be there. But we are taking away only the element of salary sacrifice. Thank you.
Okay, your answers are too brief given the length at which they went to make the inputs. Momo, do you want to say anything else?
No, I was just going to say, firstly, I'm not honorable, but to Honorable Father, I hope he and I would agree as much, because I think Chris and I agree a lot in Yanga. So we hope to find each other here, Chair. I just want to assure him and all honorable members. Thanks.
Okay, right. So basically, sorry, what's that, Dennis? What's it, Dennis?
I was saying few of us deserve that title of honorable, Eunice. Yeah,
okay. Now, look, man, can we stop the quips? Because I'm not making any quips on behaving because we're running out of time. So, look, can I suggest, firstly, that this issue, you see, it's difficult to separate the emotional, moral, and policy issues, what's right, what's rational, because anybody offering bursaries, they appeal to a right. So I mean, look, everything that Dennis says we agree with. I'm sure you agree with about the problems government has, and look, COVID-19 has shattered us, to put it mildly. But, you know, Frank and Esther, you got to help us. I'm not sure, even if we sat for another 20 minutes on this on Tuesday, not that we need to, except that MPs must get fuller replies, please. You know, we're going to come to some consensus here. Secondly, I've explained at the outset the constraints in which you're operating. But Frank, think about it. Esther and your team, think about it. Is there a way out where we can say, look, we understand both sides. I mean, this idea of equity and opening, in my words, floodgates on private expenditure and say this thing and so on. I suggest, you know what, can we all think about in our study groups before Tuesday? What we say is that, look, we hear both sides. And what we've done in the Standing Committee on Finance in the last 5 years is where the arguments are reasonably balanced on both sides, we tend to opt for National Treasury because we trust the National Treasury and the South African Revenue Service in a way to be more oriented towards the public interest than, let's say, a private sector stakeholder or anybody else, or most other people. Especially though, when you get NGOs, it's more other organizations like that. But let me put this to you. Well, two quick things. One, I agree with Dennis. It's important that you alerted that to us, Momo, about the sort of obvious disadvantage it has to Mr. Liebenberg and the lady from Edinvest. But I don't think it's driven solely by their own financial consideration. I think they genuinely have good hearts and that they are serving a good cause as they see it. But you're right to draw that to our attention. Dennis is right to say that can't be the basis on which you take a decision. Secondly, the most compelling thing you've offered as Treasury is what you argue, the equity argument. That I feel is very convincing, members. And we have to think about all those things. So there's too many imponderables, there's too many balls to jog, there's too many balances and trade-offs to find a simple answer. And I don't have it personally. I think we should collectively discuss it in the committee without the stakeholders being there because, well, they can be there, but we ain't going to have endless discussions. So let me thank both the stakeholders who have made a submission and the members for their useful contributions. National Treasury, you have to reply in fuller form to the members' concerns on Tuesday. But as for the stakeholders, you should have replied in greater detail, but we're going around in circles. I know what you're going to be saying. So Ronel and Lerato also made useful points in the chat group. I hope the stakeholders have seen that and other members have. So for now, let's draw it to a tentative close. We will take it up next on Tuesday. The stakeholders are free to connect if they want, but it's not as if they're going to be given the same space as on Tuesday and today. Now, on the matter of withdrawing retirement funds upon immigration, we've got 10 minutes or so. If we can deal with all of Saika's issues, both sides and members, let's forego Saika and they don't have to come. If we can't, we'll carry it over to Tuesday. In any case, Sharon comes to so many of our meetings that
I can't come on Tuesday.
Well, your colleagues can come. All right, so basically, on the withdrawal of retirement funds upon immigration, what have you to say?
Okay, so thank you first of all to National Treasury for the comprehensive feedback. We really appreciate it. And I must admit, for all those things that I missed, that's all on me, where you have changed in the bill.
Yes, I was going to sort you out for that. Yeah, because you're here all the time. Yeah.
My apologies. Yeah, too many things at once. So apologies from my side. You mentioned the withdrawal. I mean, the whole reason why this whole change in the withdrawal with pension funds, etc., is coming in is because you were saying that people were leaving and coming back. So they were basically wanting to take their money out, say they were immigrating, but then they come back and they've got their pension fund or access to this money. So that was the trigger. And then you also mentioned that the whole reason why you're doing this is to make sure that there's equity between the people that stay and those that leave with access to these funds. And you said it was a tax incentive that they've been given while they're here, they get a deduction for it, which is all true. But my question comes back to how many of these people are actually leaving?
Yeah, I've got that in my notes. They didn't give any figures.
How many people are, especially in light of the fact that we're now changing exchange controls to make it easier to bring money in and out of the country. So that doesn't kind of tie up for me. And the other thing is that there is tax on that retirement fund when you leave. So it's not like you're giving up. You're actually paying tax in when you're taking that money when you leave the country. So when the person leaves, the whole reason behind that is, and it is when you went through the exchange control process, as I said before, it's not a simple process, and it's quite an expensive process. So why would anybody want to do this? But if they leave, they're leaving for a reason, and I understand the concern. But the thing is why they can take it or should be allowed to take it. It's their money. They've paid tax on it. They're not apparently coming back to the country. And if they are, that's when we can deal with the situation. That's why we suggested another proxy other than the 3-year period. And I'd like to hear, just what is the abuse actually going on here? Because it's not a simple thing to do. We are changing the exchange control laws in any case. Why do we not link it rather with that and put the proxy in as either the change of residence, which is SARS is doing in any case, and is part of the requirement for exchange controls. And second of all, getting that permanent residence certificate, because you literally can't go and stay somewhere else if you don't have that residency certificate. You have to then come back. That's one of the requirements. So that is just, again, for me, just the figures on this. What is actually triggering this? Because now we're affecting everybody when I think it's only a few individuals that this is actually.
Yeah, you made this point. Yeah. I'm choosing
Number
this one.
two, if we move on to the Section 1010, I get your points. However, bear in mind that Section 1010 is actually not applicable to some of these individuals. And I just want to also point out that we've never had a chance to comment, although we raised it in all our submissions. This is the first time that we've actually commented on the change. We only saw the actual change come in now in the recent bill. So we never had a chance to comment on this before. We always recommended that a change should be made, but we didn't know what the change was going to be. So I just want to point that out. So you do mention that these individuals with the double tax, because the foreign companies are still taxing them, that they can claim the Section 6 quad. The concern there is they actually can't claim the Section 6 quad rebate because it's actually South African source income. Even the DTA with the 183 days now says that it's South African source income, so they cannot get the Section 6 quad rebate. What they can get is the Section 6 quad 1C deduction, but they again there are worse off than they would have been if, and again, not because of their own, this was out of their control. They didn't have a choice for this. So they now will have an additional thing. And then you do mention directives. It's again linking back to a lot more admin and schlep for everybody concerned and pushing the onus of proof again back onto the taxpayer. So those are the two things. I just like brief feedback on that. But the big one for me is, Frans, I'd like just some clarity on this because I'm still confused, to be honest. As a reasonable person, if I read the law now, it says that if you do not, let's take that stupid example, and I know you say it's not stupid, and I agree with you in certain cases, it is not a stupid thing that if you don't change your address. But as I read the law now, it's a criminal offense. It's either on conviction, I'm liable to a fine or imprisonment for 2 years. So and this will then have to go to the NPA who would have to, so it's a criminal offense as I understand it. And you are saying you don't have the manpower to look at all of these offenses, which I get. And that's why we are suggesting that all of these things actually shouldn't be criminal offenses, because you should be focusing on the criminals and you should be taking those criminal offenses to court. And that's what your focus should be on, not on those that are making these negligent mistakes. So maybe if you can just explain to me, and I don't quite understand.
I think your point's made, yeah, okay.
Yeah.
All right, that's done, right? So you're done, right? Okay. Yep. So what I suggest now, National Treasury, I don't think members are going to come in now. To be fair to the stakeholders, National Treasury, just reply, please, to Saika. Members can come in with their views on Tuesday. National Treasury, please be, it's 2042. I've asked for another 10-minute extension and it's been granted, but that's the most. Go for it, please, Treasury.
Sorry. Okay, so thanks, Chair. Thanks. In terms of numbers that have immigrated, we've got numbers from the Reserve Bank. There are a few thousand, and then they can take their RAs. But the whole point of this is the barriers to come back are incredibly high if you go through the immigration process through the Reserve Bank. You have to get rid of all your accounts. You have to stop your loans. You have to sign a form to say you're not going to be back in the country for 5 years. Otherwise, anything you take out of other limits has to be repatriated and taken back to the country, etc. Now, if you move to a new system, there's going to be no barriers, so that hopefully the people who leave, they can very easily come back. They don't have to close their bank accounts. They don't have to sign a form that says they're going to have to stay out. So we don't have numbers on how many are actually going to come back. The more important point for us is the equity point. And as you say, if they pay tax, it's their money. Why can't they get it? Well, why can't the individuals who stay within the country who don't actually leave, why can't they get their money? They have to wait until they're 55. The biggest point for us is on the equity point about the domestic individuals. You stay in the country, you don't leave, you want South Africa to do well, you stay here. but you don't have any access until you're 55, whereas those who can go actually do. We are actually allowing access within the 3 years. So, you know, that equity point is very important for us. The whole point on permanent residency certificates and other things, those are new tests that SARS would then have to administer. You know, all these other suggestions on can't you do this test or that test, they're new tests. At the moment, there's one tax residency test. And the one tax residency test is if you apply by one of those criteria, all in your resident physical presence, etc., then you are or are not a tax residency is one thing to look at, and that's the one thing that SARS looks at the moment anyway, including in terms of DTAs.
Yep, exactly.
The point about the comment period, they haven't been able to comment on this, is because it's a COVID measure that you are one of the commentators that put forward that we have actually now done, but we put it into this bill late so that it can actually be done. So there wasn't a period in which you could comment before. Thanks, Momo.
Sorry, Chris, if I can just
Sharon, hang on, Sharon, please.
Okay,
carry on. What else, Chris, you want to say in response to all of
Chair, let me come in as well, because I mean, I think the key point is that we don't want people to withdraw before the age of 55. Frankly, I think the current dispensation is too generous. And what we motivated, and it's not your ex-con relaxation issue. It's an issue of moving towards, like Chris says, some way of tax residency. But, in fact, I think that if Sharon were to be logical, then the issue should be that we shouldn't allow anyone to get their retirement funds before 55, whether you're in the country or out of the country. And once you reach 55, you can take your money out as it's allowed for everybody else. That would be much more equitable in my view, because you got a tax concession in the first place when you contributed.
Yeah, okay, fine. You've covered your point. You've given us a trajectory of your argument. Fine. On the other issues that Sharon raised, National Treasury, anything else is left out? As far as I can see, you covered it, right? Treasury?
Yes, they are covered.
Yeah,
Chair.
I can't. Yeah, look, basically each party must decide on this issue. I don't even have further discussion on this. On balance, it seems to me Treasury is right about the withdrawal. It seems reasonable to me, but each party can decide, including my own. On the removal of proof intent, I also think that France gave an excellent answer. If there's need for clarity, they can do this offline between now and Tuesday, France and Sharon. But can we move on now? Fair that the remaining stakeholders not be heard. So what I suggest, because of limited time, we give each of them 5 minutes at most. Treasury will not reply today. They will reply on Tuesday. Those who cannot come of these two, they can actually just connect with the YouTube later, and they can see the answers. Or Esther can, some recording can be done in Koleleko and just send it to them. So no need for National Treasury to reply. Members can come in on Tuesday. Over then to who's next? Is it SJ12 or is it the other person who's here? Doesn't matter. SJ12, can you go for it, please, quickly?
Honourable Chair, sorry, apologies. Just given the timing and that we've run over, I've had to move. Do you mind if I come in 2-3 minutes' time?
Yes, fine. So who's next in Koleleko? Is anybody else left?
There's no one left to check because Mr. Barnes has left the platform.
Why did he leave? He had to go.
Yes, he has another commitment.
All right, well, tell him that, look, in fairness to him, we'll allow him in if he can make it at 9 o'clock on Tuesday. That slot is free for us. Am I right in Koleleko?
Yes, Chair.
Okay, he's the only stakeholder who will speak then, and then we'll have the gentleman now who wants to come in 2 minutes. Where is he? I didn't quite follow why he needed 2 minutes here, but anyway.
Honourable Chair, can you hear me?
Yeah, we can indeed.
Do you mind if sorry, I've had to transit to my next meeting. So do you mind if I speak without my camera on?
Yeah, of course.
Okay, perfect. So, Honourable Chair, I think that the point, I mean, just to summarize the position is we spoke on earlier in the week around the issues regarding the fact that, sorry, my apologies. We spoke earlier in the week around the fact that when it comes to the incentive specifically, there's a bit of a timing issue around the extension with the sunset clause being in June of next year and the reality of the fact that there's still a very long process that needs to be followed before we have clarity. Younger made the point, and we fully accept the point that National Treasury have put a process in place and that they have had engagements scheduled. But Younger also did make the point that obviously because of COVID and given where the world's at the moment, that these engagements have been delayed and they're only scheduled and set to take place in December. So, you know, I think in summary, Honourable Chair, it's very clear to all of us that in June of next year, when the sunset clause for Section 12J comes into being, we will not be in a position where we've had full public engagement, where we've had a full process that's been followed, and we've been able to go down the road as regards the entire process that takes place in these matters to reach a conclusion. And I think with that having been said, as well as the fact that when I previously presented them back to you with hard facts and evidence regarding, you know, the success of the regime, which we have done, I think there is still a long conversation to be had. And, you know, in that spirit, what we would like to do is propose a compromise to this committee that we think is fair for all parties involved, which is that given the circumstances of where we are, can we have the opportunity to have a one-year extension such that we can sort these matters out, we can go through the public participation process, we can ensure that the facts and figures are correctly dealt with, analyzed, debated, discussed, and then we can reach a landing and a conclusion that is acceptable to this committee and to all stakeholders involved. I think at this juncture in South Africa and in COVID, it's too important not to do that and to allow a sunset clause to come in an SMME and job creation focused incentive that, to the statistics we've shown you, has been hugely effective for South Africa.
Are you done?
I'm done. Thank you.
Okay, Treasury, you can reply within 5 minutes.
You want us to reply, Chair?
Yep.
Okay, thank you. Thank you, Chair. What we want to state is that when the incentive was put in 2008, we said the incentive ends on 30 June 2021. There was certainty to each and everyone that the incentive is coming to an end. It never said provided that or the minister will apply his discretion whether the incentive to end or not. The date was set and concrete to say it ends at 30 June 2021. That said, we are beginning a process whereby we hear stakeholders as to what can we do in order to not to discontinue this incentive, because the date is set to say the incentive is coming to an end without any discretion to continue. So now we are listening to them, and anything can be put forward for the minister for the consideration. Thank you, Chair.
Anything else, Momo, Chris?
Yeah. What I think Younger is saying, Younger, you've got the review as well, but I think what you're saying is that, you know, for the consideration of the Minister for the Budget in February. That's the issue. But like she says, the deadline has been set. So I don't think there should be any expectation that we intend to continue with this, as we have stated previously.
Okay, right, fine. Can the members apply their mind to this? There may be a need to put something in the report about our concern about what SA12 has raised. They have, in fact, delivered. Somebody is interrupting. What's going on in political? Somebody got...
I just switch on your mic again.
Unmute, yeah. I think you muted me, am I right?
Yes, Chair.
Okay, no problem. I'm unmuted now, I take it, because you can hear me. Okay, so look, colleagues, let's apply our mind to this. Never mind what Momo and Younger says. We are Parliament. We can take our own decision on this. It probably won't be any amendment to the bill. It may mean that we put something on the report about a concern of this. And if Frank and Esther are here, start thinking about something along those lines, but each party can meet and decide its views. So what I suggest, colleagues, is thanks to everybody, including the stakeholders, in fact, mainly the stakeholders, members of Parliament, we are required to be whenever here. Now, what I'm saying is that for Tuesday, we will deal with the remaining stakeholder who didn't actually have a chance. Secondly,
what I'm saying is that my understanding in Kulileko is none of the people whose issues are raised below now, the line here, so to speak, they are here. These are the submissions made in writing. None of them is here. Am I correct?
It was only the Cape Gate that made a written submission that is here.
Okay, is he here right now?
I think he left already.
All right, so you can contact him and we, sorry, what's that? Hello? Yeah, so, okay.
He spoke already, Chair.
Sorry? What? I can't hear. Well,
Sorry,
what
Chair. The guy from Cape Gate spoke already. He had an opportunity.
Yeah, that's what I thought. That's what I wondered. If it's not the same guy, Cape Gate. Isn't that the guy in Kulileko?
Yes, Chair, yes. But he didn't make oral submission. He only made a written submission.
Yeah, that's fine. He had a say. That's the most important thing. And we did reply. National Treasury and the members also engaged. So that's fine. There's nobody who's here as a stakeholder who's not had a say. Am I right?
No, Chair.
Right. Yes, I'm right. In other words, good. Then that's done. The members can come back on Tuesday and Treasury can sort it out. So Tuesday morning, if we missed out somebody who was here and left early, let's include them on Tuesday morning. Next issue then is for National Treasury to reply to members. Then we start looking at the policy issues. And then I think we need one more sitting to vote on the report and so on. So we'll meet on Tuesday from 9 to 12, and we'll probably meet again in Kulileko. Look for a time that doesn't clash with appropriations on Wednesday sometime or Thursday sometime, but in time for voting in the House the following week.
Okay, now, Chair. Chair, you're on mute.
Oh dear, it's this. I'm on the cell phone now. What's happening now? Can you hear me now?
Yes, we can hear you.
Okay, so look, I think I've covered the ground. Thanks to everybody. See you on Tuesday. Thank you. Bye. Go to sleep, Dennis. It's
Thank
past
you,
your bedtime.
Chair.
Okay.
Bye-bye, everybody. Keep well.
Thank you, Chair. Thank you, members.